Well, good afternoon, everyone. I declare open this public hearing of the Parliamentary Joint Committee on Intelligence and Security for its review of the exposure draft legislation combating anti-Semitism, hate and extremism Bill 2026. These are public proceedings, although the committee may agree to request to have evidence heard in camera or may determine that certain evidence should be heard in camera. I remind all witnesses that in giving evidence to the committee, they are protected by parliamentary privilege, unless you are giving evidence from outside of Australia. It is unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated by the Parliament as contempt. I remind all present that as Chair, I'll ensure that proceedings are conducted in an orderly, respectful and courteous way. In accordance with the Committee's resolutions of the 26th of August 2025, this hearing will be broadcast on the Parliament's website and the proof and official transcripts of proceedings will be published on the Parliament's website. Witnesses are advised that the Committee's review concerns the exposure draft bill, not broader issues that may be subject of other inquiries, and that evidence will only be taken by the Committee where it relates to some or all parts of the proposed legislation. In addition, Parliament imposes on itself a subjudicial convention, which means avoiding public discussion that could involve a substantial danger of prejudice to proceedings before a court or other tribunal, including royal commissions, unless there is an overriding public interest requirement to do so. The hearing today is being conducted with members of the committee appearing both here in Parliament House and via video conference. Members participating remotely are reminded to mute microphones when not speaking. I also want to take this opportunity just before that we begin, just want to acknowledge the horrific terrorist attack at Bondi late last year in December, and the impact that that has had on Jewish Australians and the broader Australian community. As the Prime Minister and the government have made clear, this was an act of terrorism driven by hatred. Anti-Semitism is real and it is dangerous, and it threatens the safety and dignity of Jewish Australians and the cohesion of our nation. All Australians have a right to live openly, practice their faith freely and feel safe in their own country. And that right is fundamental and must never be conditional on fear or concealment. National unity is vital to confronting hate and extremism. And as we commence today's hearings, we do so conscious that our work here carries a real responsibility to protect cohesion, shared values and the safety of all Australians. I'd like to now welcome representatives of the Department of Home Affairs and the Attorney General's Department, and I understand also Australian Border Force. No? Okay. Maybe a bit later on, to give evidence at today's public hearing. For the Hansard record, could I ask all the officials at the table please to state your full names and the capacity in which you appear before today's hearing? We might start with the Department of Home Affairs.
Certainly. Claire Sharp, Head of Immigration.
Brooke Hartigan, Deputy Secretary Legal.
Andrew Wands, First Assistant Secretary, Criminal Justice Division.
Sarah Chidgey, Deputy Secretary, Integrity and Security Group, Attorney General's Department.
Sarah Samios, First Assistant Secretary, Integrity and Criminal Law Division.
Luke Muffet, Assistant Secretary, National Security and Criminal Law Branch.
Thank you very much. Although the committee does not require you to give evidence under oath, I should advise that as this hearing is a legal proceeding of the Parliament and therefore has the same standing as proceedings of the respective houses, giving false or misleading evidence is a serious matter and may be regarded as a contempt of the Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. And due to the short time frame the committee is working within to complete its review, please try and answer all questions or provide information to the best of your ability in the evidence today. As written answers to any questions taken on notice will have to be provided within 24 hours of receiving the Hansard transcript. Now, I just want to invite both departments to make a brief opening statement, should you have one. Do either departments have an opening statement?
Chair, neither of us have an opening statement, I understand, but I'd just note that we provided a joint submission to the committee from both departments about an hour ago. Okay, we'll make sure that that gets circulated. Okay, thank you. I understand it's been circulated. Okay, well, on that note, I will hand over the call to the Deputy Chair to kick off today's hearing. Mr Thompson, you have the call.
Thank you, Chair, and thank you all for being there today. It is a tight turnaround, and we have gone through or done our best to go through this bill, but it is quite a quick turnaround for us. And just on the outset, I fought terrorism in Afghanistan, so we didn't have to fight it here. And this bill is extremely personal, and I want to take the time to go through it. And even if it sounds like we're in the weeds or in the minutiae of this, there's a reason for it. Is because you only get one chance to do it right. And I want to start by the aggravated hate speech offence for preachers and leaders who promote or threaten violence. I think preachers and leaders is quite vague. Can you please outline exactly what a preacher and what a leader is by definition in this bill?
There are key definitions in the bill, and we set those out in our submission. Religious official would include religious officials authorised to lead or perform religious duties. Those positions would usually involve an official title and could include those in a range of positions. The term spiritual leader would include those that guide individuals or groups in spiritual practices. That wouldn't necessarily need to be official, and individuals could be spiritual leaders if they're gurus, guides, mentors. The inclusion of other leaders captures leaders who may not fall in those categories but occupy positions of significant trust or authority in the community. That could include, for example, a principal of a school, a youth group leader, and pastoral, but they'd need to be acting in the capacity of engaging in religious instruction or pastoral care.
Okay, thank you. And in relation to the changes to firearms, can the changes to the firearms that are being proposed work if state and territories do not change their legislation?
Thanks very much for the question. Ostensibly, what the bill does is set up a framework. So you have a framework that provides for a buyback. You have a framework that provides for Commonwealth intelligence checking to assist states and territories to make sure that they've got intelligence from firearm decision making. And you have some customs restrictions. The first two that I mentioned obviously leverage off state and territory responsibilities. They have primacy for legislating around firearms. The third one is import controls at the border that the Commonwealth has responsibility for. So in terms of a buyback, what you can see from the legislation is it sets out the framework. There will need to be discussion and agreement, as the Prime Minister has said, agreement at National Cabinet around the reforms and the buyback for that to work. With the intelligence piece to that, again, sets up a framework, but that will need to be leverage off state and territory frameworks to allow for decisions of the Commonwealth that are passed to state and territories for information for those to become part of their licence application process.
And just on that, has there been any evidence or growing evidence that you've been provided that show lawful firearm owners pose a growing threat to the safety of the public?
Thanks very much. I don't think this is the reforms are about lawful firearm owners as such. What National Cabinet has set out is an agreement to strengthen the firearms reforms, and we're tasked with developing options to strengthen those. This bill goes to implementing some of those options, particularly, as I said, the gun buyback, and then a desire from jurisdictions to make sure that there was relevant intelligence before decision makers for firearms licence applications.
And I might not have been able to find it, but non-Australian citizens, will they be able, under this draft bill or what you're proposing, be able to get a firearms licence?
So a firearms licence itself is a matter for states and territories. And the agreement from National Cabinet was to look at options for having only Australian citizens being able to get licences. We've already heard from jurisdictions that there may need to be some exceptions for that. For example, where someone is a primary producer, or you might have an international sporting competition where they might need to have a licence temporarily. So there may well be some exceptions to that. But this bill doesn't do that. This bill is about import restrictions, and there is an import restriction for Australian citizens to import guns, but it's not about the licence itself.
Thanks, Chair. I'll circle back later.
Okay. Happy to go to Senator Duniam.
Sure. Thanks, Chair. Thank you for your time today. Can I ask, the expression globalise the intifada, would that be criminalised under the bill we have before us?
Senator, it's not possible for us to comment on particular fact scenarios. So we can explain the full and physical elements of the offences in the bill and what they would encompass. But for all of the offences, they cover particular conduct, but they also go to the mind of the offender as well. So convictions for any particular conduct inevitably rely on all the facts and consideration by a court.
So what about the expression then, from the river to the sea?
I'll give the same answer.
So the aim of the legislation proposed by government is to deal with the issues that led to the terrible events of December 14, and many in the community have pointed to statements of this nature. Can you explain then for the committee how this bill, these laws, will deal with those who would make such statements publicly, which have been identified by stakeholders as part of what led to December 14 Bondi?
So the bill isn't prohibiting a series of specific statements, but I can take you to the new racial vilification offence, and that offence applies to any individual who engages in conduct in a public place, which includes speech that's intended to promote or incite hatred for any group of persons because of the race, colour, national or ethnic origin of the target or target group, or alternatively intentionally disseminate ideas of superiority over or hatred of another person or group of persons because of race, colour, national or ethnic origin, where that conduct would cause a reasonable person who's a target or a member of that target group to be intimidated, fear harassment or violence, or fear for their safety.
So in drafting the provisions that are in this bill, consideration would have to have been given to the actions that might be caught up in the legislation and therefore criminalised. And did the department or any officials that were part of the drafting consider the meaning of some of the statements I've read out? Like, do you understand what globalise the intifada actually means?
Senator, the purpose of the criminal offences is to capture appropriate thresholds. We consult, for example, the AFP on the utility of the offence generally, but not on specific scenarios. And we also develop them with regard to legal advice about the Commonwealth's capacity to legislate in this area as well. And examples of criminal offences at state and territory level as well.
So in working with the AFP and other agencies, entities, stakeholders, whoever, did you consult on some of the phrases that were part of very much the public debate that led to the catalyst for this legislation, which was the massacre in Bondi on December 14, including from the river to the sea? I mean, did the department sort of consider that as part of its thinking as it drafted up the thresholds that are now in the bill before us?
Senator, we consider conduct generally, not specific scenarios, but we're really looking at appropriate thresholds for criminalising speech. And so that has been particularly what we have had regard to in developing the offence. And the design of the offence is meant to capture a whole range of circumstances, not any one specific phrase at a point in time, but any speech that satisfies those criteria.
So the use of the expression globalise the intifada at a rally say, on the Sydney Opera House steps, clearly aimed at inciting hatred. Is that the kind of thing this legislation was aimed at criminalising?
Well, the racial vilification offence is aimed at the conduct as I've described it. So any conduct that intentionally or promotes or incites hatred or disseminates ideas of superiority on the basis of race, colour, national or ethnic origin, where it is sufficiently serious that it would cause any member of a targeted group, a reasonable member of that group, to be intimidated, fear any harassment or violence, or fear for their safety.
So if these measures have been in place prior to what happened at the end of last year, how do we think the situation would be different? How would we have prevented what happened from happening?
It's not possible for us to give an opinion on that.
So how have we drafted legislation in response to what happened to prevent it from happening if we're not sure how it will work?
The offences are designed to address serious anti-Semitism, hate and extremism generally, and designed with our legal requirements in mind, with precedents in mind, and with the advice of agencies.
Did any of the events leading to December 14 constitute serious anti-Semitism? In drafting these laws, I'm sure you looked at that.
Senator, I think that's not something the department can comment on.
So how then did the department determine the thresholds and the scope and of the penalties and the rest of everything that's contained in the bill?
I think I'd just take you to my previous answer. So through consultation, advice from agencies, through legal advice, through considering precedents and considering the sort of appropriate standards for criminalising conduct, including speech.
Okay. Just back to a question the Deputy Chair was asking before with regard to the definitions around spiritual leader and religious official, pastoral care, religious instruction. Did you say they were defined?
Sorry, I should clarify. They're the key terms used, but
Yes.
and they take their ordinary meaning, and I was just describing what that would encompass.
Okay, so can we go to ordinary meaning? How is ordinary meaning derived? How do we arrive at that?
So through the commonly understood meaning of terms, and then we have given guidance in the explanatory memorandum as well.
Okay, so a spiritual leader, ordinary meaning in the view of the department is?
I had outlined that, so and we've included that in our submission to the committee. So that term we consider would include those that guide individuals or groups in their spiritual practices. That might include faith, values or morals. Wouldn't necessarily include an official title, and it could include, for example, those who might be classified as gurus, visionaries, guides or mentors. And I note, as I said before, the way that aggravated offence works, it takes both the capacity in which the sort of position that the individual has, as well as the capacity in which they're engaging in that conduct, being religious instruction or pastoral care.
Okay, and so that could include someone who in a living room hosting a Bible study. That could include a spiritual leader, could include someone in that scenario?
Yes, where they're acting as a leader. I should say too, the aggravated offences work in this respect by aggravating the penalty or increasing the penalty available for existing criminal conduct, being advocating or threatening the use of force or violence.
And just in terms of religious official, what was the ordinary meaning behind that, sorry?
Sorry,
Religious official, yes.
So the indications we have given in the explanatory memorandum is that it would include religious officials authorised to lead or perform religious duties, such as ceremonies, rituals and preaching within their faith. It would usually involve an official title. It could include some of those you'd expect, potentially priests, imams, rabbis, bishops, chaplains, those in an official religious role.
And so in terms of coming to what a proper definition would be, the ordinary definition, to test that, it would have to go to court, right? If someone who was caught up in the provisions of this legislation and sanctioned and it found its way to court, they could contest, oh, I'm not a religious official or I'm not a spiritual leader. That would be a test for the courts, yeah?
As with all elements of an offence, ultimately the decision's made by a court or jury on guilt,
and so
having regard to the evidence on all the elements of the offence.
Was consideration given to specifically defining these terms in legislation?
Yes, we did consider that. I think we didn't want to overly limit them and felt that it was appropriate to give it an explanation in the explanatory memorandum of how they would work.
Okay. So how do we, in terms of the religious instruction component, that is defined, can you remind me? The ordinary meaning of religious instruction?
So again, it would take its ordinary meaning and capture the teaching of beliefs, values and practices of a faith.
And so if, in terms of individuals acting in these roles, religious official, spiritual leader or someone providing pastoral care or religious instruction, does the bill capture individuals who are operating online, as in, let's say they're on WhatsApp communicating with an individual or even a group? Would this bill capture people in that situation?
Did you want to talk about
Yeah, so it might be helpful just to frame this offence a little bit. So it is an aggravated offence. So the person has to have committed the underlying offence to start with. So that may be, for example, the offence of advocating violence against groups. So that advocacy could occur online, it could occur in person. So that underlying offence must be met. What this aggravated, and that is an existing offence, what this aggravated offence is doing is saying if someone commits that offence and they also meet this additional circumstance, a higher penalty is available. So it's not criminalising a broader range of conduct. It is saying that if you commit these crimes and you are doing it in this capacity, a higher penalty is available. So for the underlying offences, yes, those offences do not restrict the method through which you advocate or threaten violence.
Mm-hmm. So the changes only, as you say, go to that aggravating element. But the point is, though, with existing laws, proposed laws, someone providing religious instruction on WhatsApp to an individual or a group, provided they're inciting violence or hatred, would be caught up?
Yes, through existing offences, if they meet the requirements of that existing offence.
Yes, but that would then have that aggravating factor of them being a spiritual leader and whatever they're doing, proselytising, they might call it, we might call it inciting hatred on WhatsApp to a group, they'd be caught up, yes?
If they're engaging in that conduct in the course of religious instruction or pastoral care.
Okay, all right. The penalty for using a postal or similar service to menace, harass or cause offence, that is part of this legislation, which, as the government tell us, is a response to what happened at the end of last year. How would these measures have dealt with or prevented in some part what happened at Bondi?
Senator, we're conscious that some of the behaviour, so menacing, harassing and offensive behaviour, can form part of that broader context of anti-Semitism and hate. And we were conscious that unlike the online version of that offence, where the penalty was 5 years, the penalty for the equivalent postal offence had not been raised, so that it was the same. So we are addressing that in this bill, and it is relevant to the range of conduct that contributes to hate and anti-Semitism.
Okay. And how would these proposed provisions deal with or interact with media organisations that are reporting on hateful conduct?
So the postal service.
Yes, yeah.
So that would mean you'd have to use a postal service.
Oh, it doesn't go beyond. It doesn't cover
it applies
means.
to
It literally
use of
is
a postal
Australia
service
Post.
to menace or harass someone.
So that's not something that currently is in Australian law?
It is in Australian law. We're just increasing the penalty to align it with the
Right,
equivalent
okay.
online offence.
Right.
Where the equivalent online offence applies to use of a carriage service to menace, harass or cause offence, and we're just fixing the penalty to make it equivalent for the same postal
Okay.
service.
So then similar service, what's that? It refers to a similar service.
I think it would mean a formal postal service. So and it goes to the Commonwealth's constitutional heads of power, which apply to postal services.
Mm-hmm.
If I handed someone a piece of paper with something menacing or harassing on it, that isn't encompassed by the head of power for regulation
So
of
if you
postal
pop it in their
services.
letterbox yourself, you're not caught up under this. But if you use Australia Post or Star Trek or someone...
That's right.
Okay. And what precipitated that inclusion to increase the penalty relating to this?
We were aware that we hadn't, that there was just a discrepancy in the penalties.
Right.
And there have been instances in the past where people have used the post to engage in that conduct and are conscious that it's appropriate to make sure the penalties are equivalent.
Sure, okay. I'm not sure how much longer I have, Chair, before we go to Senator Cash. I've just got a couple more for this block and then, yeah. I just want to go to consultation with stakeholders. Is there a list of groups that have been consulted on the development of this legislation?
No, Senator.
Is there a reason why there isn't a list of stakeholders that have been consulted?
We haven't produced a list, so I think the Attorney-General has said this morning that along with the Jewish community, Christian and Muslim groups have been consulted along with legal experts, and that consultation's ongoing. The department has been involved in a number of those consultations, but we understand ministers may have been also engaging and their officers directly as well.
Okay, so and does that answer apply to Home Affairs as well in terms of your part of this legislation?
Yes, it does.
Okay. Can I ask for a list that both agencies have interacted with?
So we'll need to take that on notice. So the consultations did occur in confidence, so we'll take that on notice and see what we're able to provide.
Looks like...
And just for clarity,
yes.
from the Home Affairs perspective on the firearms, there hasn't been consultation on the bill. We've talked about the broader reform piece, so it's a little bit separate.
Yes, understood. Okay, so obviously we don't have much time and theoretically we're reporting on this bill on Friday, so I'd appreciate as early as possible an answer to that question, and I expect we'll be potentially having a hearing with some of these stakeholders this week, if they happen to be on a list. How many Jewish groups, for example, did the Attorney-General's Department consult with in the development of this legislation?
So, Senator, just because the department hasn't done all the consultations, I don't think we can answer that. So a number of Jewish organisations, but I don't have a number for you.
So yes, sorry, not talking about consultation in totality. You mentioned before the minister or her office, the attorney or her office may have done some of that. I accept that, but in terms of the department's role, traditionally departments will go and consult with stakeholders about bills that have some impact. So how many have the Attorney-General's Department consulted with?
So we'll need to take that on notice.
Were there any, the department specifically?
We have been involved in consultations with the Jewish community, but I can't speak to the number of organisations.
And when you say involved with consultations, what does that mean? You didn't lead the consultations, it was done somewhere else?
I think generally, well, it's a mix of consultations and quite a number of those also involved the minister or the minister's office as well.
Okay, so who organised those consultations?
Again, a combination of, the consultation's ongoing, the Attorney-General's office has been involved as well as other offices, and we have assisted with some organisation. Okay.
Did the Attorney-General's Department organise any consultation with, for example, we'll start with this, Jewish representative groups as a standalone from consultation with the attorney or her office?
I think we haven't, I'm not aware, we'd take it on notice and confirm. I don't think we've done any without involvement of the Minister's office.
Okay. And what date did this consultation start?
We need to take that on notice.
Was it in 2025?
We will need to take that on notice.
It was only less than a month ago.
Yes, we've been obviously doing a lot of work very intensively, so we will just need to take that on notice.
Okay, so...
And as I said, the department has had some involvement, but we're aware that ministers have been engaging as well directly.
Yes, but ministers aren't drafting the legislation. The department are the experts who draft this, and we respect you for your work, and so having that input from third parties is critical in terms of getting this right, especially given the truncated nature of what we're doing here.
I would just say that ministers have been very closely involved in the development of this bill.
Yes, I can appreciate that, although I don't expect they're sitting down in the department typing out elements of legislation. That's where expert drafters come in. So moving off Jewish groups for a moment then, and I very much look forward to those answers around how much consultation has occurred. Or one last question on that. Were those groups that were consulted with to date and are being consulted with, has anyone been provided with a complete exposure draft of the legislation prior to yesterday? Or I think it went online on your website this morning.
So there were some provision of draft provisions. Obviously, the bill has been a work in progress, so the draft was finalised prior to submission for this committee.
Okay, and just on, you've taken on notice this. So in terms of those who have been consulted, beyond Jewish groups more broadly then, who was on the formal departmental consultation list and who was on the unofficial consultation list of the Minister? If we can have those, that would be helpful, because between the Minister or the Attorney doing her work and her office and the department, there must be a capacity of the work that's been undertaken over the last nearly month, provide a list of who on both streams of work, and I know some of it is combined. It shouldn't be beyond us to figure out where that occurs, and the nature of the meeting. Was it online? Was it in person? If I could have that on notice as well.
So I've taken on notice to see. We don't have a list. Also the names of individual organisations that were consulted in confidence. So I've taken it on notice and I'll see what we're able to provide you.
And indeed, and in those situations where a third-party organisation doesn't want to be named, I mean, I'm sure that at least it could be said that a meeting occurred with an organisation that, name redacted, Section 47C or whatever.
I guess what I've been able to say is just the types of groups that have been consulted. As to whether we can give the names of individual organisations, I'll take that on notice.
Yes, of course. Okay. And in terms of this consultation process, can I understand then how much of that has actually gone into the formation of the legislation as it is here today?
I can say it has informed the development and final form of the legislation.
Okay. Were religious groups consulted on the Part 5 racial vilification, the defence there under subsection 4? Does not apply to conduct that consists of only directly quoting from or otherwise referencing a religious text for the purpose of religious teaching or discussion. Was that provision provided to any of the religious stakeholder groups that any or all of the religious groups that were consulted?
There are religious groups who have been consulted on the provisions, on the draft provisions.
Were all religious groups consulted on that provision?
I'd have to take that on notice. And as I said, we haven't necessarily in the department been directly involved in all consultation.
Why would some groups be consulted on it and others not?
Part of it is point in time. So obviously we needed to reach a point where there were draft provisions in some cases. So some of those consultations involve more general discussions on policy, and then for some consultation, provisions were shared once they'd been developed.
Okay, and were any non-disclosure agreements signed as part of the consultation process?
No, not that we're aware of.
Home Affairs? No?
Not that we're aware of, no.
Okay. And with the provision of whatever elements of the draft legislation, noting what you said, at a point in time, things will be more developed later than they were earlier, were representatives of these groups able to take proposed legislation with them, or was it all a case of being shown a document, take notes and leave?
I think in most cases they were given an ability to look over a draft rather than take one away.
Okay, and were any copies of proposed legislation sent out for consultation, or it was all done in this arrangement where people were gathered in a room looking at a hard copy?
It's a point in time, but I think most of it, and again, I would say that we can only speak to consultation that the department was involved in, but the consultation we were involved in, there were provisions sort of provided within the consultation session.
Okay, and who, so just on consultation generally, who was on behalf of the Australian Government in charge of consulting on this very important legislation?
Well, it's obviously shared work between Department of Home Affairs and the Attorney General's Department, the two relevant ministers, and the Prime Minister and his office had involvement as well.
So who was in charge though? That's everyone who was involved, who led that process. Because of course, you know, when a government is dealing with multiple groups and you've got multiple arms of government seeking to extract information from these third parties, you don't want to double handle, you don't want to miscommunicate, etc. So who was the person or entity in charge?
Well, there's different components of the bill. So where it involved legislation administered by the Attorney General's Department, that was led by the Attorney General's office, using other, working with other ministers' offices for some consultation where that was relevant. Obviously, there's gun reform and other elements in the bill as well, but, and ongoing work with states and territories. So there are just different components.
A bit separate, yes. Okay. Were the intelligence agencies consulted on the drafting of the legislation?
We definitely had engagement with ASIO.
With ASIO, not with any of the other?
I'm just checking. I'm assuming you're still talking about the hate crimes component here, because
there's hate crimes, and then we can come to obviously the firearms element, which of course I expect there was consultation on, given it refers directly to them. But we'll stick with hate crimes for now.
For the hate crimes component, engagement, because of the nature of it, was primarily with ASIO, AFP, and the Commonwealth Director of Public Prosecutions.
Okay, and so engagement with, were they providing input into the drafting of the legislation?
Yes.
They were, and were they provided copies of the legislation?
Yes.
On the way through? Okay. All right. I wonder then, just on notice, if between knowing that there is a separate body of work there, which agencies were consulted, on what date they were consulted on respective parts of the legislation, Chair? I'm happy.
If I could just quickly on that point, it was an ongoing iterative discussion with those agencies, like they were very closely involved. I think we'll struggle to say on what date, because in many occasions it was almost a daily interaction with them. So
sure, as best you can then.
Well, we can articulate which agencies, ongoing discussion with them.
And maybe over what period perhaps, or something like that. That would be helpful. Well, just on that, before we do go, what was the first date on which, with hate crimes, interaction between ASIO and the AFP occurred?
I think we'd need to take that on notice. It's just been, quite intensive engagement all the way through. So we'll need to.
Do you know whether
notice.
It was 2025 or 2026?
We'll need to take that on notice.
It was 2025.
2025?
Yeah.
Okay, thank you very much. Chair.
All right, I'll hand the call now over to Senator Cash.
Thank you, Chair, and thank you all. If I could just quickly follow up on some of Senator Dunnigan's questioning, bearing in mind we're obviously hoping to get the answers back tonight in relation to these questions so we can continue with the hearings tomorrow. Just when was the legislation finalised?
I think the draft was for this.
So the version that you have before you was finalised yesterday.
Thank you very much. In terms of Senator Dunnigan's questions regarding consultation, can I just confirm Home Affairs' answer in relation to the gun aspect? Did you say that you hadn't done any consultation?
No, that's not what I said, Senator. What I said is we've been consulting more broadly since the National Cabinet announcement. So we've had meetings with both gun safety advocate groups and groups like sports shooters groups. We've also done extensive consultation with states and territories that have included multiple meetings of senior officials from states and territories, meeting both before Christmas and after Christmas, and the Minister also chaired a joint, along with the Attorney-General, a joint meeting of Attorneys General and Ministers of Police to discuss some of these reforms. But it hasn't necessarily been bill-specific, which I think is really important.
No, that's the point I'm making. We're sitting here today, this is the PJCIS, looking at the text of a bill. Have you consulted on the exact text in toto of the bill?
We haven't shared draft provisions.
No. Can I just confirm also, Ms Chidgey, how many stakeholders across Australia were provided with a complete copy of the legislation that we are currently looking at as the PJCIS?
I'll take that on notice.
Okay, well, the good news is we're hoping to get those questions back tonight. Can I ask, when you were consulting, were the stakeholders able to take the legislation away and discuss it with their relevant stakeholders?
As I'd mentioned previously, the consultations we've been involved in, they were provided with draft provisions for some of those consultation sessions within that session.
Now, when you say draft provisions, we're going to need to know if you could provide this on notice, and given you're involved in these consultations, I'm assuming the department has copious notes. For each stakeholder that you consulted with, what provisions were they provided with? If they were not provided with the entire bill, how are they meant to comment in isolation on those provisions as they relate to the whole bill? Can you please take that on notice, Ms Chidgey?
Yes, I'll take that on notice.
Thank you very much. Can I just confirm, did you give evidence that, to the best of your knowledge, no non-disclosure agreements were required to be signed?
That's correct.
Okay. Were there any confidentiality requirements? So, for example, if I was shown specific provisions that you have referred to, was I then allowed to go and talk about these provisions publicly and give you feedback?
Free flowing.
Senator, our understanding is, because we didn't necessarily have all of the organising conversations for those consultation sessions, is that in cases they're allowed to have a discussion about the legislation within their organisations.
Right, okay. Was that a public discussion?
It was within their organisations.
So it wasn't a public discussion?
Well, it was understood that we were consulting in confidence, but we didn't ask anyone to sign non-disclosure agreements, and it was understood that...
That's all I needed to know. And thank you very much for that. Can I now turn to specific questions in relation to the defence religious teaching or discussion, section 80.2 BF, in brackets number 4. So this is the defence that has obviously now been raised in the newspapers. In terms of the exact text of the bill that we have in front of us, that we are inquiring into as a committee, how many stakeholders were shown that exact text?
We need to take that on notice.
Okay, again, this is very important. If we're being asked to turn a bill around by Friday, with all due respect, my expectation is you will be able to answer that for us by tomorrow, because it will inform the questions that we need to ask the witnesses tomorrow. When was this defence in particular section drafted?
Obviously, the bill on the work on the bill has been ongoing and developed over the time we have worked on it. We'd need to.
I know what you're saying. Can you please take on notice? Because again, I've done this a million times, as you know, as many around this table have. I need to understand exactly when this defence first commenced, why it was put in, and when it was finalised, and based on what consultation. Can I ask
Senator, I could just add a little bit on the defence. So there is
I've got a series of questions actually. It might be better just in terms of, I'll ask my questions on so that you know exactly what I want to know. Was Sheikh Shadi Al-Sulaiman provided with a copy of the defence prior to it being finalised?
We'll take that on notice.
Was Sheikh Shadi Al-Sulaiman allowed to consult on the defence, or on this particular section of the Act?
As before, I'll take that on notice. I'd indicated that given the consultations were confidential, we'll need to take on notice disclosing any individual stakeholders who were consulted.
Well, the problem we're having, these are some of, and the Prime Minister said, some of the widest ranging changes to laws this country has ever seen. We are now being told that the Australian public, and in particular the Jewish community across Australia, are not entitled to know who was actually consulted. And so unfortunately to me, I have to ask the question, what is the government hiding? Why cannot you tell us here and now, did Sheikh Shadi Al-Sulaiman, was he provided with a copy of this particular text?
Senator, I've been able to say that the consultation included Jewish community representatives as well as Christian and Muslim representatives and legal experts. Are we talking
about this particular section as finalised and we have in front of us?
So a number of stakeholders have seen provisions, Senator, and I've just taken on notice.
Are you able to tell us who those stakeholders are?
I've taken on notice that question.
Why can't you tell a public hearing of the PJCIS who these stakeholders are?
Because they were consulted in confidence, and so I need to take that on notice and see what we're able to provide.
Okay, can I just quickly ask some questions on this particular defence? Just confirming the term religious text as defined in the section, does it cover both the Quran and the Hadith Sunnah collections?
So, I think, again, with this provision, we have again left that term to take its ordinary meaning. And so... And we've explained it in the explanatory memorandum as to how we think that would operate.
Right. So we're talking about an exemption here for people who are otherwise spreading hate speech. Okay, that's basically what we're talking about here, and in particular when you read verses from the Quran as they relate to Jewish people. So, the Quran and the Hadith, or the Sunnah collections, obviously have specific meanings within Islam. I need to understand clearly, are both covered by the exemption, or is it only the Quran?
Senator, that would be considered by a court. We would take it to be the central text of any religion, but it would need to be considered by a court, and we've explained that it would include scripture, translations of texts that are of central importance to the religious practice of various religions.
So in terms of religious text then, as defined, does it include commentaries, liturgy, catechisms, etc., or is it only narrow scripture?
It is the religious text rather than commentary that people write about religious texts.
Right, so now I need to know what safeguards exist to prevent extremist speakers from weaponising quotations, reading out inflammatory passages to intimidate a target group, and then invoking this defence as a shield?
So it would depend on the context, but if, as the defence says, that conduct is particularly within those terms, so it's only directly quoting from or otherwise referencing a religious text for the purpose of religious teaching or discussion, any extraneous commentary statements that are outside simply a direct quote would not be protected by that defence.
So if an extremist preacher avoids commentary and relies on quotation only, given some of the disgraceful things that can be said about Jewish people, to maximise protection, does the government accept the defence may therefore unintentionally now incentivise hate preach?
So it is a very specific defence, so it's directly quoting from or otherwise referencing a religious text for the purpose, the sole purpose of religious teaching or discussion.
And I go back to my question, and I'm happy to provide you, so you can comment on each of them, some quotes from the Quran. If an extremist avoids commentary and relies on quotation only to maximise protection, does the government accept the defence may unintentionally incentivise that behaviour? This is the whole point of the bill. We are meant to be tackling what occurred post-October the 7th, 2023, anti-Semitic behaviour, and yet looking at this defence, there is a very, very good chance that the government, in placing this defence in there, is actually going to incentivise hate speech. How does that not occur?
It is a very narrow defence. So as I have said, any surrounding conduct could be considered for the purpose of the offence. The defence purely applies to a simple direct quote from a religious text for the particular purpose of religious teaching or discussion. So if anyone was quoting for other purposes, the incitement of hatred and their surrounding conduct indicated that, the defence wouldn't be available.
So what stops a hate preacher structuring a sermon as only scripture readings?
It would have to be for that purpose as well, and their conduct as a whole consist only of quoting from the religious text for the purpose of religious teaching or discussion.
Discussion is very wide. We now please start defining discussion.
It has to be a religious purpose. So if the purpose was inciting hatred, and all the facts would need to be considered, but it could be that that would fall outside that religious purpose.
So in other words, there's no answer to this. The answer that you have therefore given is A, it's up to the courts, but B, there is actually at this point in time nothing in the legislation that goes to the points made by Peter Wertheim, who I have to say, I would have thought his opinion was incredibly important, that stops a hate preacher structuring a sermon on scripture and having a discussion so that they fit the defence. So you could say, here is a quote from the Quran. Let's now discuss this quote in the context of genocide in Gaza.
Well, Senator, it's probably worth making the point as well that this defence is very specific to the vilification offence. So there are a range of other offences that would apply irrespective of whether there were quotes from religious text. If you were, for example, an individual advocating or threatening the use of force or violence, that would still apply.
Senator?
So does promote BARDA mean advocating violence?
Sorry, what was that, Senator?
Does promoting intifada mean advocating violence?
We don't comment on particular fact scenarios and what would be caught by offences, but anything
So
that...
do you know, the Attorney General's Department know what intifada is?
Senator, I'm not going to give an opinion on particular facts, but we are saying that there are other offences for advocating or threatening the use of force or violence.
Again, though, and I'm not trying to be smart here, this is very serious legislation. The whole point, as Senator Duniam articulated, is that we are meant to be responding in this legislation to the anti-Semitic behaviour that has been allowed to fester in this country, resulting in the deaths of 15 people late last year. And at this point in time, all I'm hearing is we can't tell you anything about the consultation. We've thrown in an exemption that now may actually allow hate preachers to structure sermons to ensure that they have a defence. We're not prepared to comment on is globalise the intifada covered. We're not prepared to comment on is from the river to the sea covered. We don't want to actually talk about intifada. So I'll ask you another question. Is a fatwa issued by a religious leader considered a religious text?
So I would give the same answer as I did before, that we're talking about religious texts that are the scripture or text associated that underpin that religion. So not extraneous commentary or other materials.
So I need then, a fatwa is a non-binding legal opinion or ruling, as you know, on a point of Islamic law, Sharia law, issued by a qualified Islamic scholar, otherwise known often as a mufti, in response to questions about religious matters. Is this covered as religious text? This is a very important point.
Senator, it's not possible for us to give definitive examples of the range of religious text, but we have indicated what explanation we've included on that in the explanatory memorandum.
Could I just ask, in what circumstances could someone, other than obviously journalistic, educational, etc., utilise, globalise the intifada or from the river to the sea in a non-hateful way?
Senator, I think we can just take you to the terms of the particular offence and what they capture, rather than commenting on whether any particular fact scenarios would be criminal.
So I need to go then back to, and this is the important point in what you've said. You keep referring to discussion. So couldn't someone just quote from, say, the Quran and then discuss religious implications, for example, a fatwa, and they are able to invoke the defence?
No, the discussion is separate. It only captures quoting for the purposes of discussion. If you then went on to engage in a broader discussion...
I don't actually understand that then. You're going to have to now explain that to me. So I understand quoting directly, I do not understand quoting for the purposes of discussion then.
So the quote is then for the purposes of discussion. If separately, when you're discussing that quote, you engage in conduct, the individual engages in conduct that promotes or incites hatred or intentionally disseminates ideas of superiority that is outside quoting from the religious text, that would be caught by the offence.
So you're able to have a discussion on something that is potentially anti-Semitic and hateful, that is okay?
Well, I mean, obviously the discussion could involve specifically recognising that while the text itself did not represent the values of the religion, you could still have a discussion about it in a way that didn't promote or incite hatred.
Right. Can I just ask, on the 28th of March 2025, scholars from the International Union of Muslim Scholars issued a fatwa. They stated the following: jihad against the Israeli occupation is an individual obligation upon every capable Muslim, while calling upon every Muslim government to intervene immediately through military, economic and political means. Again, going back to the basic question of religious text and the definition, is this a religious text?
Senator, if it assists, so I can't add to Ms Chidgey's evidence on commenting on particular factual instances applying, but the way the exception is structured is really two required parts. It has to be, the conduct has to be that direct quote of religious text, and that quote has to be occurring in religious teaching or discussion. So if in religious teaching or discussion words are said that aren't direct quotes, this exception does not apply. It is only reading from those religious texts in that context that this exception applies to. When we look at how this offence sits in the broader suite of criminal law at the Commonwealth level, there is a group of offences that sit above this that involve advocating or threatening violence. When that violence threshold is present, there is no equivalent defence there. So when you sort of refer to other statements that may be advocating or threatening violence, this exception, this defence, does not apply to those offences. So really what this offence is saying is that it is not an offence under this provision, 80.2bf, as proposed in the bill, if you are directly quoting, and just that conduct of directly quoting, for the purpose of a religious teaching or discussion.
But hold on, you can't tell us what a religious text is.
I think that the challenge, as Ms Chidgey has sort of said, is applying facts to a legal test is one that a court has to consider the context of that, and us, the department here today, aren't in a...
What you're saying is you've drafted this legislation. We're being asked to turn it round in record time, and I still can't get an answer to other than we don't comment on specifics. The court will need to determine. I am at a loss to understand how globalised the Intifada is not inciting hatred, how from the river to the sea is not inciting hatred. And you can't define religious text. It is a simple question. And this is actually a very serious one. I'm sorry, but the department should not be leaving this to the courts. Is a fatwa a religious text if it is a religious decree issued by the leader of the faith group? It is actually a simple question.
So Senator, just to go to the first part of that, how we frame criminal offences is generally focused on the intent of the person, not the words or the precise methods they use for that. So this is around promoting or inciting hatred. That can occur through a whole range of words. If we limit to particular words, it just allows people to adjust their words to get around the criminal offences. So what this is saying where a person engages in conduct, any conduct, whether that is through words or other actions, and that conduct is intended to promote or incite hatred or disseminate ideas of superiority, that is the conduct the offence applies to. So it's ensuring that it is resilient to changing facts over time, because the criminal culpability comes from that intention.
So my question therefore to you is this: is the exemption an acknowledgement that the Quran and associated texts therefore contain anti-Semitic teachings? And if so, why is the government seeking to make an exemption for anti-Semitism? If it's not an acknowledgement, then why is the exemption required?
We are not making that statement. I think the defence recognises that there are some historical religious texts that may contain archaic language, and that simply quoting from them for the purpose of religious teaching or discussion with nothing more should be considered a defence.
Chair, at this point in time, I'll place further questions on notice, but I just on that, the offence requires intent, is that correct?
That's correct. For the element of intentionally promoting or inciting hatred or disseminating ideas of superiority, for the aspect about the effect of that conduct on a reasonable member of the target group or the target, strict liability applies to that element. So the prosecution would not have to show that the offender was aware of the effect of the conduct on a reasonable member of the target group.
But why do we need the defence?
The defence narrowly applies to quoting from religious text.
And why? But why do we need why do we need? What type of religious text are you talking about? Is it anti-Semitic text that you're saying? Well, there is anti-Semitic text out there in scriptures, etc. And that's going to be a problem for us because we said we'd tackle anti-Semitism as a government. Now we have actually a problem, so we're going to throw in an exception so that you can still quote from these anti-Semitic texts.
So, Senator, the offence applies in relation to conduct targeting on the basis of race, colour, national or ethnic origin, and we haven't reviewed all religious texts, but it is a recognition, and as I said, I think New South Wales has, for example, in their offence, a defence equivalent to this, and that is designed to recognise that some historical religious texts may contain archaic language.
So can I also then ask, just for clarification, and we'll need this tonight if you can't give it to us now, or alternatively, can we go into camera and you can give it to us in camera? Who asked for the defence? Was it the Jewish community? Was it the Islamic community? Was it another community? And obviously this is incredibly important for us in terms of understanding exactly why the offence is there. If you intend to promote hatred, or why even have the defence? If you are simply considering religious text in good faith, I would argue you do not have that intent. The concern I now have, based on the answers that I've been given, and the reason we need answers to these questions is to actually discuss this in a public forum, not behind closed doors with third parties. Does this defence actually now mean that we have a roadmap to anti-Semitism? You have just acknowledged that the reason we need the defence is there are anti-Semitic passages in some religious text.
I haven't said that there are anti-Semitic passages in some religious texts. The offence, as I mentioned, applies across race, colour, national or ethnic origin. There could be circumstances where texts touch any of those attributes of a group. This defence is intended to provide some assurance that merely quoting with nothing more from historical religious texts would not engage the offence. And as I said, part of the development of the offence and defence, we looked at other precedents and examples of offences, and a similar defence exists in New South Wales.
No, and I also understand what the feedback from the Jewish community was in relation to that. How will decision makers determine whether the purpose was religious teaching or discussion? Is it assessed objectively?
Yes, it would be assessed objectively by a court based on all the evidence. And a defendant would have to adduce some evidence that would suggest a reasonable possibility that that exists in the first instance, and then the prosecution would have the opportunity to disprove the existence of that defence.
So under this legislation with the defence, an imam could read anything from the Quran while preaching at, for example, a mosque. I mean, obviously it's a lot wider than that, even if it is anti-Semitic. And there's a defence if they've totally stuck to the words of the scripture.
I think that over-characterises the application of the defence. So, because anything beyond directly quoting could be taken account of for the purpose of...
That's not what I said. I said mine was very, very specific. You can read anything from the Quran at a mosque, even if it's anti-Semitic, and they will have a defence.
So if you're only directly quoting from a religious text and quoting from it for the purpose of religious teaching or discussion, you will have a defence. If there's any other surrounding conduct, that would not be covered.
I understand that. My point is, you've answered it. Is the department going to publish worked examples so faith communities and the police actually understand what the boundary is?
No, we don't. As we wouldn't for criminal offences, we don't publish fact examples that would be caught by offences.
Okay,
other than in sort of more general terms, using the terms of the offence.
I have a lot of questions that obviously will be going on notice, but with all that was very kind of you to give me that time. I'll hand back to Senator Dunningham or the Deputy Chair.
That's right. I'm just going to rotate the call slightly. So I'm just going to go to Dr. Reid and then Senator Smith and then Senator Grogan, and then I'll come back to the opposition. But I understand government members also have some questions. Not many, but they have a couple of questions they'd like to ask now, and then we'll come back to the opposition. So Dr. Reid, you have the call.
Fantastic. Thank you, Chair. And to all those appearing before the committee in Canberra, thank you very much for your time today. My questions go to the racial vilification offence, and they're more broad questions rather than minutiae, just so that we can get that sort of broad concept on the public record. So my first question is, with regards to the racial vilification offence, what type of conduct is intended to be captured as part of this new offence?
Senator, Dr. Reid, sorry. I'll take you just to my earlier answer. Apologies. So I think we can't give, particular fact examples that would result in a conviction, but can take you to more the terms of the offence, which can capture a whole range of conduct. It's really about whether it meets that threshold of intentionally inciting or promoting hatred, or it's disseminating ideas of superiority, targeting anyone because of race, colour, national or ethnic origin, and where it meets that added threshold that a reasonable member of that targeted group would be intimidated, harassed, fear violence or fear for their safety.
Thank you. And then just on you were just mentioning reasonable person of the targeted group, with the bill containing elements about the reasonable person of the targeted group. Can you explain why that test or this test is required, and have you received any advice about why it's required? And also too, are there any sort of constitutional implications if it's removed?
So this is the reasonable member of the targeted group element.
Yes.
So there are a number of reasons, the first of which it's important to ensure that the offence doesn't capture more trivial or frivolous conduct, and that's particularly the case with ideas of superiority. So it helps ensure, for example, that it wouldn't capture things like individuals indicating that people from their country have better food, play sport better, those kinds of things, which could otherwise be captured particularly by that superiority limb, and provides a level of objective seriousness for conduct that would be caught by the offence. And the way it's been drafted, where it applies to a member of the targeted group in all the circumstances, ensures that it takes account of the experience of members of that group in determining that. So the sort of background of experience of harassment, violence, intimidation or exclusion can inform how the effect on a reasonable member of the targeted group when the offence is being considered. And we have developed this offence with regard to the Commonwealth's constitutional requirements and legal requirements as well. I can't provide the committee with the content of that advice, but we have had regard to the legal requirements for the Commonwealth to legislate.
Okay. And sorry, my mind's jumping around a little bit. I apologise. There was just one final question I had, and I believe there's reference to strict liability elements in the offence provision. Can you just explain the rationale for their inclusion, please?
That's right. So strict liability applies to that element of the offence that a reasonable member of the targeted group would have that fear. And strict liability applies, so the offender would need to intentionally incite or promote hatred or disseminate ideas of superiority. But strict liability means that the prosecution wouldn't have to show that the offender was aware that their conduct would cause a reasonable member of the targeted group to have that fear.
Right, okay. Thank you very much. Thank you, Chair.
Thanks, Dr Reid. Senator Smith, you have the call.
Thank you, Chair. Just checking you can hear me okay?
Yep, all good.
Great. I've got some questions which go to prohibited hate groups. So first up, I was hoping the department could step through for us how the listing regime for prohibited hate groups differs from the listing regimes for terrorist organisations and state sponsors of terrorism.
Yeah, thank you very much. So I'll step through that in a couple of different ways. I might start with the threshold because that's the critical question here, is what makes a group fall within one of these frameworks. So for state sponsors of terrorism and terrorism organisation, that obviously relates to terrorism, as it says in the name. Those groups are engaging in supporting, advocating terrorist acts. What this framework is looking at doing is capturing groups that are engaged in, have engaged in or supported or advocated the doing of a different set of criminal conduct, being what we refer to as hate crimes. Now, hate crimes is defined in the legislation by reference to existing Commonwealth offences, but also by reference to conduct involving serious physical or harm or property damage to groups where that harm is because of the attributes being race, national or ethnic origin of those targeted groups. So the thresholds are different in the types of criminality the groups are concerned with. The other key difference in the threshold is the AFP minister in this framework, being the Prohibited Hate Groups framework, not only must consider whether the group has been involved in that criminal conduct, but also must consider whether it is reasonably necessary to list the group in order to prevent harm to the community from the commission of hate crimes. So ensuring that the listing is proportionate and necessary. That proportionate and necessity test also flows through into an ongoing obligation on the minister, where if the minister ceases to be satisfied that it's reasonably necessary for the group to be listed in order to prevent harm to the community, the minister has that obligation to delist the entity. So the other critical difference in the thresholds for prohibited hate groups, before the minister can even get to the point of considering that, the minister must have received advice from the Director-General of Security in relation to the risk the organisation poses in relation to promotion of communal violence and politically motivated violence. So it is really a Director-General of Security, being the Director-General of ASIO, that initiates one of these listing considerations. Similar to the listing of state sponsors of terrorism, you also have, which has a requirement to consult the foreign minister, given the inherent foreign relations sensitivities in listing a state sponsor of terrorism. Here, because of the nature of the conduct and the need to balance and consider different issues around legality and human rights and free speech and things like that, there is also a requirement for the agreement of the Attorney-General prior to listing. There is then a number of similarities I'll just mention in terms of this committee's ability to review the listing at the time it is made, as well as an ongoing mandate to be able to review the listing at any time into the future, so long as that listing remains valid.
I might stop you there because I have a few questions of some of the things you've listed so far. Before you continue, if I can just interrupt you, if that's okay. So just coming back to the role of the DG of ASIO and the requirement for them to provide advice, can you step us through the reasons why the government included this step, and also what matters in particular the DG would need to consider before his advice was provided?
So before the Director-General can provide advice, the Director-General needs to be satisfied of one of the following matters: that the organisation has engaged in activities where the Director-General is satisfied the activities or the continued engagement in the activities would or are likely to increase the risk of politically motivated violence or the promotion of communal violence. Those terms are defined in the ASIO Act, and they would apply equally here. As an alternative, the Director-General may be satisfied that the organisation has advocated for or engaged in politically motivated violence or engaged in the promotion of community violence, or that their activities indicate a risk that they may advocate or engage in that violence in the future. So the Director-General, based on all of the information available to them and their organisation, when satisfied of those thresholds, then may make a recommendation to the AFP Minister.
Mm-hmm. And can you step us through why the government has included that step? What's the rationale for that?
So this is really going to formalising and making sure it's a requirement that a listing decision is intelligence-led and is really responding to a concern from our intelligence agencies and taking into account information from law enforcement about the necessity of it before the minister can act.
Okay, thank you. And you started to speak briefly before I interrupted you regarding oversight for the decision to list a hate group. Specifically, I'm interested in what the role of this committee will be in that under the legislation.
So for those that are familiar with the terrorism framework or even recently the listing of the Islamic Revolutionary Guard Corps, the committee will have the same functions and mandates they do in relation to those frameworks as they do here. So the committee is able to obtain briefings from relevant agencies and departments following the listing of an entity to understand that and provide a report. And then that ability to review a listing continues for the period the group is listed. So a few years from now, if there was concerns about whether a listing remained appropriate, this committee could initiate on its own motion a review into that.
Okay, thank you. Can I also ask what, if any, defences will exist for these offences?
So to take you to the second part, so these offences only apply where a group has been listed. So they cannot apply by the court thinking that a group meets that criteria. An active decision is required of government to bring the group within this regime. And then there are 6 offences that attach to interactions with groups that have been listed. Some of those offences have offence-specific defences embedded in them. For example, the membership offence has an exception where if the person is able to prove that they took all reasonable steps to cease to be a member as soon as practicable after they learnt that the group had been listed, that would the offence would not apply. Similarly, for the funding one of these organisations, there's some offence-specific defences in there around legal representation and provision of legal advice. There are also some general offences that apply to all of the offences there around when someone is engaging in their role or their official duties and responsibilities as part of being a Commonwealth, state or territory official. So, for example, a law enforcement official. And then so they're the specific offences, and then obviously the general defences in the criminal code would apply here as they do across all criminal offences.
So, with respect to offences and associated penalties, can you talk us through where those might be similar to those in the listed terrorist group regime and where the differences might be?
Between level of penalties?
Yeah, the offences and associated penalties.
Just 1 second. So, yeah, as I mentioned, there are 6 offences here that have a rough equivalent offence across those other frameworks. So a lot of these offences have 2 tiers. So the person intentionally engages in the conduct, whether that be directing the activities or being a member, not being a member, or recruiting. In there, the person, if they know the organisation is a prohibited hate group, there is a higher penalty, and if they were reckless as to whether they were a hate group, there's a slightly lower penalty. So for those offences that have that 2-tier sort of knowledge and reckless element, the terrorist organisation and the state sponsor penalties for directing where they know it's a terrorist organisation or state sponsor, it's 25 years, and when they're reckless, it's 15 years. For prohibited hate groups, where they know it's 15 and where they're reckless, it is 10. That is also that same level is across the recruitment offences, the funding offences, and the providing support offences. For the offences of membership, that does not have the 2-tier penalty structure. In the terrorist organisation frameworks, it is 10 years. In the prohibited hate groups, it is 7 years for being a member. And for training involved in the relevant organisation, again, does not have that tiered penalty structure, just a single penalty. For terrorist organisations, it's 25. For prohibited hate groups, it is 15. So those penalties really reflect the nature of the organisations we're talking about here. As I started, where for terrorist organisations, state sponsors, these are groups involved in terrorist activity, which is one of the most serious offences we have on the statute book. To list an organisation as a prohibited hate group, they are involved in hate crimes, which are a very serious offence, but relative to terrorism is less serious. So the associated penalties for associated or engaging with those groups is proportionately lower.
Great. Thank you very much, and thank you for forgiving my interruptions. There were just a few things we needed to get to the bottom of. But thank you, Chair. That's all for me.
Oh, okay. Now we'll quickly go to Senator Grogan, and then I'll come back to the opposition. Senator Grogan, are you there? She may have fallen off. That's right. Well, we might come back to Senator Grogan. Now, Senator Grogan, I think, is just joining the call. Look, Senator MacDonald, are you there?
I am, Chair.
I know you had some questions. I'll come to you and then I'll come back to Senator Grogan. Senator MacDonald?
Thank you very much. And thank you very much to the departments for being here to provide evidence this afternoon. I just want to, I know there are a lot of Australians watching at home this committee hearing. This is the explanatory memorandum that we received last night and the exposure draft. Just want to be clear that we are considering that level of detail in this very short committee hearing today and tomorrow. And so as Australians are following along this very important discussion on the legislation, I just think we need to be clear that the consultation we're doing on this is incredibly important. So my first question is, you spoke earlier, speaking to Senator Duniam, about consultation. I'd like to know, has the legislation changed significantly since the consultation that was carried out with the groups that you have not yet identified, but you will identify on notice?
I can say that there have been changes. The bill obviously has been developed over time with input from agencies and a range of stakeholder groups, and we have taken that on board and made changes as the bill has developed.
So have you gone back to those organisations that you've consulted with to consult further on the changes that have been made to the legislation?
So I think what I could say is that there's probably different consultation at different points, and on some occasions there's been multiple discussions or consultation from conversations about policy settings, as well as then sharing of provisions that we've worked on. So in some cases it's been an iterative process with stakeholders.
Okay. One religious organisation that I spoke to said that the first they were aware was a half an hour meeting that they had last week. They were shown the legislation, they had to sign a non-disclosure agreement, they weren't able to take any photos or take any records back to discuss with their organisation. They just had half an hour to work through this document, to take notes. And then they had to wait until this morning to be able to see and print the legislation in full. That doesn't seem a reasonable period of consultation for Australians to be discussing whether or not this legislation is reasonable. I won't ask you to comment on whether or not you believe that's a reasonable amount of consultation, but I would just put that on the record that I don't think that's a reasonable amount. I want to turn to the gun legislation, the buybacks that has been included in this omnibus bill on hate speech. Can I ask, was that a recommendation of the intelligence agencies that gun legislation be included in hate speech legislation?
Senator, in my experience, intelligence agencies wouldn't recommend what provisions go in what bill.
I'm trying to understand why you would be including such disparate pieces of legislation in the one bill, given that we are, I assume, trying to ensure that we wouldn't have another incident like the Bondi massacre. And so could you explain to me why you've decided to include both lots of, both pieces in this one piece of legislation?
Senator, I think what we can say is the Prime Minister, Minister for Home Affairs and Attorney General have said that the purpose of the bill is to include all priority provisions in this legislation to address both the motivation and the means in the context of dealing with anti-Semitism, hate and extremism. And that includes both hate speech on motivation and reforms to deal with guns and their availability as well.
Okay. I want to turn to your submission document. In part 5, the racial vilification offence on page 8, that works through some of these new offences. Just want to turn to where you've spoken about expressions of race, colour and national or ethnic origin. And it says on the 4th line there, for example, those of Jewish origin would be protected by the offence. Given that Jewish people, I could convert to Judaism, how then do you suggest that you'll be protecting Jewish people of different ethnic origins under this legislation?
So for this offence, that reference draws on the Racial Discrimination Act, and it is in that context these terms have been found to encompass Jewish people, also Sikhs, as ethno-religious groups.
Okay, so you would be satisfied that using that basis, that people chanting "Gas the Jews" or "Death to Jews," that would encompass that group of people, despite them, you know, it might be a Ukrainian Jewish person or a person from Israel.
Yes, so we're satisfied that that reference to persons or groups distinguished by race, colour, or national or ethnic origin encompasses Jewish people.
Okay, what about other religious groups? Would it protect, well, I'm Catholic, would it protect Catholic people?
I mentioned that I think there has been consideration that it will apply to Sikhs as also an ethno-religious group, and in other contexts it would depend on the broader range of characteristics, but being Catholic alone would not constitute race, colour, national or ethnic origin, but it might be that in certain circumstances, if there are broader other considerations that meant those individuals formed part of one of those groups, that would be covered.
What about Christians more broadly then? Would that be considered covered by this legislation? Would that group be considered protected by this legislation?
As just an entire group of Christians, that wouldn't be, but there could be particular Christian groups that might pick up those characteristics.
All right. Do you feel satisfied that there was commentary earlier that descriptions and definitions in this legislation would need to be decided by the courts? Is it the view of the department that that is an adequate way to go about trying to prevent a future Bondi massacre? Because I assume that that is the intent of what we're trying to achieve here, is to stop anti-Semitism and massacres. That not being specific enough to stop those kind of events, that leaving it to the courts is an appropriate way to move forward?
Yes, we do consider that where we have relied on the ordinary meaning of terms, that is appropriate, and there can be clear disadvantages to applying very specific definitions of terms, because it has the risk that you then omit things that should be covered by the offence. So allowing terms to assume their meaning in the context of an offence for consideration by a court is an effective way of scoping these offences.
Okay. I want to turn back to the gun buybacks. Schedule 2, I'm sorry. Let's turn back to my page here. In Schedule Part 2 regarding the firearms background checks, the information sharing reforms in the legislation, currently I understood that agencies can share information for background checks now. What will they be able to do through the AusCheck Act changes that can't be done now?
Yeah, thanks very much, Senator. So you're correct in that intelligence agencies can share information with states and territories now, and that sharing does happen. What this framework sets up is a clear ability for Commonwealth agencies when a firearms licence is kind of being considered for a check to happen through AusCheck, and that's what the legislation amends to enable, set out the framework provisions for how that might occur and include firearms background checking as one of AusCheck's possible roles there. That will allow ostensibly a name of a licence holder to go to AusCheck for AusCheck to then check that with a security assessment from ASIO and a criminal intelligence assessment from the ACIC, and that's where you see changes to the legislation for those two agencies as well to permit those checks to happen. That would then allow information to come back to AusCheck about whether someone was considered adverse or non-adverse, and so if there's an adverse assessment, that would then be handed back to the licensing agency with that advice that the Commonwealth Intelligence Holdings suggested there was an adverse check. It would obviously be up to the states and territories, as I think I discussed earlier, to amend their legislation, should they wish, to enable an AusCheck adverse outcome to mean that someone isn't granted a firearms licence, because firearms licensing is a matter for states and territories.
So you've just given 2 examples there. Do you have a complete list of what will be included in the firearms background checks made through AusCheck?
So there would need to be, there's ongoing discussions with states and territories, and there'll be regulations that enable generally AusCheck background checks that'll provide further detail. This sets out the framework, and then the further detail would be in regulations, as is AusCheck's current sort of work that they do through the aviation and maritime security cards.
So they'll be included in the federal AusCheck legislation, not in the proposed state legislation?
That's right, that's right.
Okay. Will the activities of immediate family members be included in a person's background check?
The intention is that would be captured, yes.
Who has been consulted regarding these checks?
So we've been consulting with states and territories, and obviously the intelligence agencies that are involved as well.
Okay. What about organisations, particularly peak farming groups, sporting shooters, recreational shooters?
I've had some conversations with shooting groups, not on the provisions, I want to be clear to say, but on generally that what was coming out of National Cabinet about intelligence checks. And again, I won't talk to specifics about who I've spoken with on those, but generally supportive of the notion that there should be some form of intelligence checking.
So have concerns been raised regarding these checks, or people have not been provided with any detail on them yet?
I think it's fair to say that there's further consultation that'll occur now the legislation's public, Senator.
Okay. Can you provide details on how the firearms buyback scheme will practically work?
Those details are still to be negotiated and worked through with states and territories. What the bill does is provide a framework for the buyback to occur and for appropriation to happen, the details of what's referred to in the bill as the National Firearms Program will be determined.
Okay, so until legislation is passed in states or territories, or in New South Wales's case amended, they won't be able to take part in the framework.
I think not 100% clear on that question. Sorry, were you talking about until the Commonwealth legislation is passed or until state and territory legislation?
No, state and territory. You're saying that there's going to be a framework federally, but in order for it to take practical meaning, there will have to be state and territory legislation passed, or in the case of New South Wales amended, in order for that to take effect with the federal framework.
That's what we'd expect, and the government's been clear that it expects strengthened firearms laws in order to be able to access the buyback.
Okay, so if there are states and territories who don't wish to take part in the scheme, then they will fall outside the framework. They won't access these buybacks.
That's a matter for states and territories, but I think it should be clear that out of National Cabinet, which included all First Ministers, was a commitment to look at these options to strengthen gun reforms, and that a buyback would be considered as part of that.
Yes, considered, looked at, but no commitment to do that. I'm wondering why the government then, the federal government, has introduced this before agreement has been made with all the state and territories.
I think I answered that question previously, Senator McDonald, that it sets up the framework to allow that to occur.
Okay, even though it may not occur. What feedback has been given from each of the states and territories regarding this legislation? And I'm of course assuming that each of the states and territories have seen this legislation in full.
The states and territories haven't seen the legislation in full. As I said, we've been talking about the policy parameters. We've discussed the sorts of legislation that we were looking at. But there's two tracks running here. There's the things that are in the Commonwealth's purview to legislate, but the National Firearms Agreement sits outside Commonwealth legislation. And so we've been having detailed discussions with senior officials about all of those items that sat within that National Cabinet agreement to be looked at for options, as we mentioned before. So there's, as I mentioned to one of the previous senators, there's been multiple senior officials meeting, police ministers and attorneys general joint meeting to discuss strengthening national firearms laws. These laws that are here are the Commonwealth components of what is required for a framework to strengthen laws.
Okay. Given this legislation, the government wants to push it through in a very short time frame by next week. Do you intend to consult with these affected groups outside of legislative bodies, like farmers, sporting shooters and others?
We do intend to consult more broadly and continue the consultation that's happened with some of those bodies you spoke of, and continue consultation with states and territories as well.
Okay. What is the government's plan for illegal weapons? Will the buyback scheme include those weapons?
That's still a matter to be determined as part of the broader buyback details that I mentioned. I will note there is a permanent amnesty to hand back weapons now, but whether or not they're included in the buyback is to be determined.
Right, so if people hand in illegal weapons, there's an amnesty, they won't be charged for handing those back.
That's correct. Correct, sorry, there's a permanent amnesty that's ongoing.
Okay. How do you see this buyback stopping another Bondi attack?
I don't think I can comment on whether it will stop another specific attack, but I think removing large numbers of weapons from the community is something that reduces risk, reduces harm, and I think the Prime Minister and other ministers have been very clear that there's more guns now than there was at the time of Port Arthur, and the intention of the buyback is to reduce the number of firearms.
Significant number of those firearms are now illegal weapons. I'm just wondering how you see those being captured by this buyback scheme, given that they are, by their nature, not registered and not legal. What incentives will you be providing to people to hand in weapons that aren't legal?
I'd always hope that people would not hang on to illegal things, but I understand your question and I think I said that it's to be determined whether the buyback will provide any compensation for those.
Okay. Schedule 2 introduces spreading hatred and extremism as an explicit ground for refusing or cancelling a visa for those not passing the character test under the Migration Act 1958. Can you provide examples of what will be considered hatred and extremism?
Senator, I think consistent with Ms Chidgey's evidence earlier, it's hard to give exact examples of the sorts of commentary that might be spreading hatred and extremism. I might go to the process. We look carefully. We do have existing grounds based on inciting discord or vilification. And in that situation, we look carefully through what the person has said, the context in which they've said it, and then apply. It's an administrative decision. So it's either the view of the minister or the decision maker as to whether that does promote hatred of a particular group.
Would family members not passing the character test be grounds for visa cancellation for a person? For example, if the son or a daughter of a person is proven to be spreading hatred and extremism, would this be cause for a father or mother to also have their visa cancelled?
Not as it would depend a bit on so if the primary visa applicant had their visa cancelled, then it may be a situation where a secondary visa applicant, or if the secondary person's visa was dependent on the first person's visa, it's possible, but it wouldn't be the ground for the cancellation of the second family member wouldn't be the comment of the first person. It would be, for example, sorry, I'm not explaining very clearly. If the primary visa holder, for example, was a skilled visa holder and their visa was dependent on, and then the primary person's visa was cancelled, and the secondary visa, so such that that person had to go home, and the secondary visa only reason for being in Australia was to accompany the first person, then I guess that situation could arise. But the secondary person's visa isn't being, but the secondary person's visa isn't being cancelled because the first person of their association with the person's hateful comments. It was simply as a matter of law, they're here to accompany the primary visa holder.
And I'm just trying to think of the example of the tragic massacre. The son is an Australian citizen by virtue of birth. Whereas and was being investigated prior to the shooting, whether or not that would have affected his father's visa status.
No, the son is an Australian. No, not to comment on the specifics of your example, but the conduct of an Australian citizen, the fact that they've got relatives who are visa holders doesn't affect the status of the relatives.
Well, this is exactly what we've just talked about in Schedule 2. You've said that family members, we're discussing family members not passing the character test to be grounds for visa cancellation. And the example I provided was if the son or daughter of a person is proven to be spreading hatred and extremism, if this would be cause for the mother or father to have their visa cancelled. What we're trying to get at is some very specific, this is a response to a very specific issue, being this massacre.
Senator, I just want to also draw to your attention to the statement that I made earlier at the start about going too close to maybe the ongoing investigation and the Royal Commission. So I just want to make
I completely understand, Chair. So let's just pick out. You understand the example I'm trying to give, though. This legislation could potentially seek to examine a character test for visa cancellations, and I'm seeking to understand whether sons and daughters, family members, would affect that status and that visa. That is all I'm simply trying to do, but this was a very specific and good example, I thought, that would highlight where I was trying to go.
Rather than answering a specific example, I would just note that the character test if somebody's visa is being considered on character grounds, it's based on the character of the visa holder.
Okay, so if they have related members who are problematic, that wouldn't affect their visa application.
It's based on the character of the visa holder when we're considering whether to cancel under those
I have to move the call around, but you've got a few more questions left.
I do, thank you very much, Chair. I won't be too much longer. I want to turn to part 3, the breadth of aggravated sentencing factors. Part 3 applies aggravated sentencing to all Commonwealth offences if the conduct was motivated by hatred. This is very broad and applies even to non-violent regulatory offences. Referring to the Crimes Act of 1914, section 16A2MB, this sentencing elevation applies to every Commonwealth offence. How does the government apply hate crime elevations to minor regulatory or administrative offences where hostility might be incidental to that conduct?
So we'll just mention that the relevant hatred is against a group or member of a group distinguished by race, national or ethnic origin. So it's got that scope in terms of the hate motivation. It was required that a court take hate motivation where that is the motivating factor for the offence into account, and that could be for any Commonwealth offence. Very clearly, and that consider that in terms of the severity of the sentence within the existing range. Very clearly, there'll only be some offences where hate motivation arises with that offence as a relevant consideration. For example, if you're engaging in the online menacing, harassing or causing offence, it could be a hate motivation factor there. There will clearly be other Commonwealth offences where it is hard, if not impossible, to imagine hate motivation arising. And in that case, it simply won't be a relevant aggravated sentencing factor for a court to consider at all.
Okay. Regarding the proposed section 80.2BF, the government's decided that a religious official should face a 12-year sentence while a secular leader committing the same act may face a lower penalty. Why do we separate the status of the speaker rather than of the act?
So it could be any leader. I think the particularly relevant aspect is, so it could be any other leader of a group, but it needs to be relevant to religious instruction or pastoral care.
So I might just clarify there. So I think you're referring to the aggravated offence back in part 1, which aggravates where you have a religious leader that is engaging in those base offences, being advocating or threatening violence. So those offences have penalties which will be raised by this bill to 7 years, or if the conduct threatens the peace, order or good government of the Commonwealth, to 10 years. When, for the 7-year offence, if that is engaged in by a religious leader, that moves to 10, and for the 10-year offence, it moves to 12. That is different to in 80.2BF. That is a separate offence, which relates to inciting or promoting racial hatred.
And I should say the aggravated sentencing factor requires a court to consider hate motivation within the existing maximum penalty range. For the aggravated offences for preachers and leaders, they're new aggravated offences where there is an increased penalty available in those particular circumstances.
Okay. Look, I do have quite a few more questions around the legislation. Chair, do you want to move the call
Yes.
and come back to me if we have time?
Yep, thank you. All right, now Senator Grogan, I think, has a couple of questions, and then I understand I'm going back to Senator Duniam. So, Senator Grogan, you have the call.
Thank you, Chair. I appreciate. I'll be as swift as I can. I'd just like to thank you all for coming, and I know in a few short weeks. There's an awful lot of very complex work that you've been tasked with, so thank you for all that you've done there. I just want to quickly go to the migration amendments. Now, my understanding is it is about controlling the spread of hate and extremism and protecting those vulnerable groups. But can you just take us through the changes to the Act that relate to refusal and cancellations? What are the changes, just at a high-level summary? But who will these changes apply to particularly, and how do they differ to the current situation of cancellations and refusal grounds?
Certainly. So what the changes to the Migration Act do is introduce new and more specific grounds under the character test. They are intended to more expressly articulate the kinds of conduct and statements that mean someone should not hold a visa in Australia. So as the basics, all non-citizens must hold a valid visa to enter and remain in Australia. And to do that, you must pass the character test. And so what we're doing is, and there's a range of different ways that you can fail the character test already. Relevant ones for, just for context, currently are that a person does not, by their general past conduct, indicate that they fail the character test, and also that the person hasn't engaged in inciting discord or vilifying a part of the population. That's the current test broadly. What we are doing is introducing in much more specific terms the types of conduct or statement that can cause someone to fail the character test, and they are that the person is or was a member or associated with an organisation that's a prohibited terrorist organisation or a prohibited hate group, that the person has been or is involved with conduct constituting a hate crime, and earlier Mr Muffet took us through what a hate crime is. We pick up the definition in the Criminal Code. That the person has made or endorsed one or more public statements, whether that's in Australia, overseas or online, and that involves dissemination of ideas based on superiority over or hatred of other people based on their race, colour, national or ethnic origin, and in addition to that they've said something like that, that conduct gives rise to a risk of harm to the Australian community or a segment of the Australian community. And the intention is that by being much more specific about what kinds of statement, it's much clearer and easier for decision makers to make decisions to cancel a visa or refuse a visa where we see that kind of statement, for example, on someone's online accounts. The other change the bill does is for the existing section 5016D, which sets out the ground that includes inciting discord and vilification. We're lowering the state of satisfaction that a decision maker must reach from, at the moment it says that the word would is used, that they would incite discord or they would vilify, to they might. That lowering of the test, again, is intended to make it easier and simpler for a decision maker to reach the administrative law state of satisfaction they need to be able to validly cancel or refuse the visa. Who it might apply to is, just as I was articulating, it is the actual person making the statements. That's who will fail the character test or engaging in the conduct.
But effectively applies to anyone with a visa in this country, or applying for a visa.
Yes, provided that they make such statements or engage in such conduct.
What I'm trying to say is that the changes apply across the board to everyone, so it just, yeah.
Any non-citizen.
Yeah. And I noted in the EM there was some reference to exclusion periods.
Yes. So currently there is, so an exclusion period is essentially saying that if somebody's currently the regulations provide that if somebody's visa has been cancelled under section 501, 501A or 501B of the Migration Act, they are permanently excluded from having another visa to Australia. That's if the visa is cancelled. The change we're bringing in through this bill is to make it the same if their visa is refused under 501, 501A or 501B. So we're basically bringing the effect of a visa refusal into line with what is already the law if you have had your visa cancelled.
Excellent. And just finally, are there any changes to any other review options if people think that the assessment is not accurate?
No, Senator. The changes are purely to who might fall foul of the character test. Once we get to the point where we're going to where we want to exercise a power, the powers to make decisions remain the same, and the review framework, the procedural fairness frameworks, all remain the same as is currently provided for in the migration.
Excellent. Thank you. Yeah, thank you so much. That's really helpful. Thank you, Chair.
Thanks a lot, Senator Grogan. Now I'm going to hand the call over to Senator Duniam.
Thank you, Chair. Just on this matter of hate crime, I just wanted to carry on there. I just am trying to understand the racial vilification offence. That is not specifically referenced as a hate crime, is it?
It will be captured. So how that definition works, it says an offence against, the first, so it says an offence against the Division 80.
Yes. So that includes 82BF.
82BF will be situated in that and not excluded.
Okay, so it is captured in that by extension. Okay. Just then under 114A3, subsection 2, it says a hate crime is also conduct that was engaged in at a time before provision referred to in subsection 1 commenced. So I presume that is retrospectivity.
It really reflects the ability, when a minister is considering listing an organisation, he can or she can consider past conduct. So this definition is not talking about retrospective application of the criminal law. It's not saying that someone would go to prison if they engaged in this conduct before this offence this provision came into force. What it is saying is that the minister can consider that past conduct where it occurred prior to this provision commencing.
So it's only insofar as it relates to the listing.
That's right.
Okay. So, but arguably someone, a religious leader or someone could have streamed a talk 3 or 4 years ago, and that would form part of the, on the basis of this subsection, part of the decision-making of a minister to list a group as a hate group?
That's right. I'm just trying to find, there's a express reference in 114A.4 in relation to the minister being able to consider past conduct, including conduct that occurred prior to the section commencing, in forming the view that a group meets the criteria to be listed.
Okay, all right, that is helpful. But so, to be absolutely clear, even though, as defined, it would indicate that an individual had committed a hate crime, but no offence is, there's no penalty for that, it just relates to the listing. Is that correct?
That's right. I would say a lot of that conduct could well have been a criminal offence at the time, but for the purposes of this framework, what we are talking about is the minister can rely on conduct that occurred prior to the commencement of this framework. If it falls within that definition, if the conduct constituted one of those things in the definition, that can be relied upon by the minister in being satisfied this threshold is met.
Sure, okay, all right.
And I should say, just to add, to be really clear, a conviction is not required. So
yes,
the minister
I did
can be
see that
satisfied.
Yeah. Okay, if we can just go back to this issue of religious text that we talked about a bit earlier on. In the explanatory memorandum, page 139, paragraph 262, it talks about what, as Chidgey said before, about the term to take its ordinary meaning, includes scripture, translations of texts which various religions consider to be of central importance to their religious practice. I mean, again, we're not looking at defining that, or the law will not specify what is a text or what is not. Islam have the Quran, but they also have the Hadith, and various versions of it. Is that something that was in contemplation when we were talking about religions considering text to be of central importance to their religious practice?
We wouldn't comment on individual texts that are in. I think the key for us is that it is texts that religions consider to be of central importance to their religious practice, and there'd be the process for a court to consider that, with the defendant having to put forward evidence and the prosecution being able to counter that.
And is there a threshold for central importance?
I think that is our view of the kinds of texts that would be captured by this.
But what does that mean, though? I mean, there are supplementary documents to a central, like the Bible. There are various other documents that scholars have argued should have been included in the Bible. As I said before, the Quran, and then you have the Hadith, which is those further guides to life, as they call them.
Ultimately to be considered by a court, but it would need to be a central text. So it's not that...
I guess that's my question.
Sort of anyone within a religion who's commenting or writing other documents that relate to the religion. But the issue with a definition is also that you can run that risk of excluding things that should be included, or otherwise having it too broad. So we think the ordinary meaning is appropriate in this context. And as I said, it does follow the same form that has been in a defence that is in New South Wales.
Yes, which of course was of concern to some religious groups based on some of the submissions I saw to the New South Wales process. But so I was just, as you say, ordinary meaning, that's fine, which religions consider to be of central importance. So we must have some way of measuring what central importance is to provide guidance to courts around how they would apply that.
So we don't provide guidance to courts. They will consider the ordinary meaning of that term in the context of the particular offence and based on the evidence that a defendant and a prosecution present.
Okay. I mean, look, as I say, in Islam with the Hadith, you have the stones and trees Hadith, which has been talked about a lot in the lead up to today. And it's one of great controversy, which talks about that the day of judgment will not come until Muslims fight the Jews, at which point stones and trees will call out to Muslims to kill the Jews hiding behind them, and so on it goes. I mean, that could be considered a central text, and that is something that in public commentary has been referred to. And so I just wonder, has any consideration been given to this defence and being able to quote what might be a religious text of central importance to that religion somehow being acceptable in the eyes of the law before us here?
So we haven't considered the wording of particular religious texts. The defence has been included to provide, I think, a level of assurance that merely quoting from a central religious text in the context of religious practice would not alone be caught by the offence.
Okay. Back to the briefings with stakeholder groups. You've talked about how the briefings, Ms. Chidgey, were confidential, but no non-disclosure agreements were signed. On what basis were they confidential? Who sought the classifying of these briefings as confidential?
So, Senator, I think Carter indicated we weren't involved in all of the arrangements to set up those meetings. We're not aware of any non-disclosure agreements that were requested. It was understood in the way that those consultations were conducted, in some of them that we were involved in, that we were providing the provisions for them to look at within that consultation environment, but not take them away.
Sure, but you mentioned that they were confidential, and so I'm just trying to understand who sought the confidential nature of the briefings that were...
I mean, I think that was understood from the context, quite what...
The department was there to provide technical support. Where there was a question about the specifics of the bill, we could help explain how that works. So we were to support with as sort of experts in how that works.
Right. So that is interesting because I had understood that before the department had actually undertaken some consultation itself, but you're telling me that it was there to provide technical support as part of something organised external to the department, I presume being the minister or their office.
I think we'd indicated that in most cases at least an advisor from the minister's office was involved in those consultations.
Okay.
Obviously they're ongoing at this point, but
Sure.
the bill is now also public.
So just back to this notion of confidential, I think, Ms. Chidgey, did you say it was just understood going into...
I just can't fully comment because we were involved in the way that Mr Muffet said, and where provisions were provided, it was in some of the ones that the department participated in, it was within the context of providing the drafts within that session that clearly had a level of confidentiality, and that we weren't allowing, people weren't provided with text to take away or sent the provisions of the bill.
Right, so the confidentiality related to the information they were being provided, draft copies of the legislation, yes?
Within that context that I've given you already,
yes? Okay.
Yes.
But not in relation to their identity and participating in the briefing?
I can't speak to that.
Who can speak to that?
The consultations in many cases were organised by ministers and officers.
Okay. In many or all?
We might have been involved in some of the setup of recent ones, but I think really it was all organised largely at ministerial level.
Right, okay. In terms of the briefing or material that was provided to the department in your role as providing technical support to these briefings that were occurring, but were there any documents provided to the department to assist in the drafting of legislation around perhaps organisations that have been through a similar process in New South Wales, for example?
Sorry, can you just clarify?
Any of the stakeholder groups that you engaged with, did they provide any written material that assisted the department in its briefing effort, in its drafting efforts?
So certainly in some cases we receive written comments.
Are you able to provide those to this committee?
No, I will take that on notice for similar reasons that are those were provided directly for the purpose of consultation, not for broader sharing.
And indeed, I appreciate the need.
And I should just mention, obviously, as part of this process, there'll be an opportunity for any of those organisations to provide submissions should they wish.
A rather truncated opportunity, but one nonetheless. Just in terms of that material, though, I suppose I'd be indicating the opposition's willingness to, given the confidential nature of these materials, if it were the committee's view to have a further hearing with agencies and, if need be, have an in-camera session, because I think some of the materials might be quite informative. Noting you've taken it on notice, but that might assist in providing whatever information to this committee, given as a parliament we'll be asked to pass these laws within 7 days or thereabouts. That would be helpful. So we might, in the break, talk about that.
We'll have a conversation afterwards. Yeah.
Okay. Senator Smith before was asking about the prohibited hate groups listing process, and I don't want to go back over all of that, but a couple of questions I have there with regard to the listing process. So can the minister request information to initiate the process, or does the minister have to wait until the Director-General of Security is satisfied that the thresholds in 114A5 have been met?
So there's nothing that precludes a minister seeking information from agencies in the usual course as they could on any matter, but a recommendation from the Director-General of Security is required before a minister could ask the Governor-General to make a regulation specifying an organisation.
Okay. So the minister could seek the information. What would the minister do with that information if a listing process couldn't be initiated until the Director-General has indicated his or her satisfaction with those thresholds having been met?
So ministers receive intelligence information, other information from the agencies within their portfolios. There's nothing in this that precludes that process from happening. Before listing, they would need this recommendation as set out in the legislation from the Director-General of Security.
Okay. Was there any feedback from stakeholders provided relating to the thresholds in 114A5?
We have to take that on notice.
Did you consult with any stakeholders that would be considered expert in the field of such thresholds and how they would operate in law?
We consulted with ASIO on this provision, and the Department of Home Affairs also engages in for listing processes, providing advice as they do for statement of reasons for terrorist organisations. So we've had that engagement with experts within government. And did Home Affairs officials have a particular view, or does the set of thresholds as they are outlined here accord with your advice to Attorney Generals?
Thanks, Senator. We have been involved heavily in the creation of the bill, so we've been consulted throughout on the thresholds and the other parts of its contents.
Okay. Are there any corresponding amendments to the AUSTRAC powers to allow them to investigate and disrupt funding to prohibited hate groups like listed terrorist organisations?
There's no consequential amendments, so I might pass to Mr Warnes in terms of whether any existing mandate that they have would apply.
I think I'd have to take that on notice, Senator.
Yeah, I mean, AUSTRAC pretty central to matters money and
they have a broad remit in relation to sort of proliferation financing, terrorism financing and money laundering, but on the specifics of the question, I think I'd have to take it on notice.
So, yes, I'd appreciate that because obviously there are those specific provisions around funding going to or from or however else it's phrased. But, yes, if you could take on notice why there's no corresponding amendment, that would be helpful if it was an oversight.
I think where there are funding offences, AUSTRAC's powers would be engaged because that is money laundering, because it's that provision of funds becomes the proceeds or instrument of crime.
So it was deemed not necessary to have further amendments because the existing laws would be enlivened because of the Act. Yeah.
For criminal offences that work in that way, where the funds are related to criminal offending, it would pick up.
I think if the conduct amounted to money laundering, AUSTRAC will have the remit.
They'd be activated.
Yep.
Okay. All right.
I'll take that one off notice.
That's fine. If you take that on notice, Mr Warnes, that would be excellent. Just in terms of the reference to consultation, it talks about at a point, I can't remember where in the bill, that the Leader of the Opposition is consulted with regard to listing of a group. Why is it not the same with a delisting arrangement?
So the requirement to consult with the leader of the opposition is consistent across the terrorist organisation, state sponsor of terrorism and prohibited hate group frameworks. What the delisting provision is really saying is when the minister is no longer satisfied that a group meets the threshold, it needs to be delisted. So if a requirement to obtain or to consult there, you could end up in a situation where the minister is no longer satisfied the threshold is met and it's no longer necessary. It's just about making sure that there's a strict obligation there that if no longer satisfied, and that satisfaction or lack of satisfaction may come from various different sources, there's an obligation to delist.
An obligation to delist. But sorry, my question was around why have consultation on the way in, into listing, but not on the way out. Sorry.
So I think it's about determining when something is, we have to justify very strongly when something should become criminal. Mm-hmm. If the minister's no longer satisfied that it should be criminal, we need to make sure that there's a swift process for moving that out. That is consistent across all the other frameworks as well. There is no, for terrorist organisations or state sponsors of terrorism, there's no requirement to consult the Leader of the Opposition to delist. If the government no longer considers they're meeting the legal threshold, the obligation is to remove them.
Is there any other consultation required for delisting, like with this committee?
So there is an obligation to consult the Attorney General for delisting.
And that is also with listing, isn't it?
Yes.
So why consult with the Attorney General for delisting, which is consistent on the way in and on the way out, but not Leader of the Opposition?
I think it just reflects the fact that the Attorney General has that legal role, and her department with the Australian Government Solicitor is usually central to providing legal advice on these matters.
And so why is the Leader of the Opposition included for listing?
I mean, I think it's the approach we followed for the listing regimes of appropriate to inform the Leader of the Opposition when there'll be a newly listed organisation proposed.
Is it just informing or consultation?
It's briefing.
Briefing, okay. So provide a briefing, obviously, because there'd be a degree of community interest, and I suppose having a participant in the democratic process informed is important. And that's why, I mean, if we think about some of the groups we're talking about here, Hizb ut-Tahrir, for example, there's a lot of community interest in that, and so listing them would necessitate that briefing, as you say, with the Leader of the Opposition. Similarly, given what occurs in public debate, I'm just wondering why we say that the Attorney General has a legal role on the way in and clearly on the way out. Have we determined that the community interest component, and as it relates to the democratic processes, is not as important for delisting, and so therefore briefing the Leader of the Opposition is not?
I think it would be very problematic to include it in the same way, because those subsection 2 aspects for delisting, it's before listing and then before making a declaration for delisting. As Mr Muffet has said, there's really a requirement once the legal thresholds are not satisfied to take that action. So beyond the sort of legal aspect of the Attorney General's role, providing for a range of other briefings before taking an action that is just necessary at law wouldn't be an appropriate inclusion.
Okay, but you say it's consistent across all of the provisions. That makes sense. Just in terms of 114A9, it talks about this committee. It says that this committee may review and report. Is there a reason why it's may rather than must?
It's really just standard practice about not trying to bind the committee, to allow the committee to form its own views about what it chooses to inquire into and how it targets its focus. So it's ensuring that the committee is empowered, but also respecting the role of the committee to determine what it would like to look into.
Okay, that makes sense, and I know we're up against
That's right.
3. I'll just ask one more question. Just on page 19, 114B2, is it the case that there is a possibility under this membership of prohibited hate group that someone can, if they relinquish their membership of a prescribed group, they can avoid criminal consequences under these provisions here?
So the offence, because it does not apply retrospective and it only is applicable once a group has been listed. So following a group being listed, If a person continues to be a member at that time, the criminal offence would apply. There is under subsection 2, which talks about that the offence would not apply if the person can prove that they took all reasonable steps to cease to be a member as soon as practicable after they learnt the group was a prohibited hate group. So as soon as they know about the listing, they relinquish their membership.
Okay. So, and we don't determine a period of time or a window of time, but the courts will determine on the facts.
And it would depend on the circumstances in terms of how you would go about doing that and the membership structure or arrangements of a group.
Okay. All right. Thank you very much. Thank you, Chair. But I think perhaps it won't be the last we see this crowd.
Look, I'm sure we'll have many conversations between now and then. I think now Jerome's online. Yes, Mr. Laxall, you're online. You have a couple of questions, and then we'll keep going with the program.
I do, Chair, and I just want to make sure you can hear me.
Yes, loud and clear.
Okay, great. And thank you for the opportunity to ask questions. I just wanted to ask a little bit about the aggravated grooming offence, and I just wanted to understand if the department could provide a brief overview of how this new offence would operate.
So this again is an aggravated offence. So it is not creating new criminal conduct. It is saying that when existing criminal offences are engaged in and an additional circumstance is met, a higher penalty is available. So the underlying or the base offence that we talk about are offences around advocating violence against particular groups or disseminating and otherwise sharing violent extremism material. So when those offences are committed and the person is doing that conduct and they're advocating another person engage in violence or they're disseminating violence and extremism material to another person, where the other person is a child, these offences would come into play in recognition of the sort of the vulnerabilities of a child and the influence this sort of radicalising conduct has on a child and the increased risk there, to ensure that that's regarded as an aggravated factor and makes available a higher criminal penalty.
How much of an issue is sort of grooming, particularly towards children and young people, you know, in the context of this legislation, but also the broader intelligence environment?
I think the issue of youth radicalisation is a very real problem and a really central problem for law enforcement and intelligence agencies. So if you look at the number of children currently before courts on terrorism offences, we are seeing a dramatic increase in children. But if you also look at the government's counter-terrorism and violent extremism strategy, that really recognises there too the central risk of youth radicalisation in the threat environment.
And this, the objective of this obviously is to try and deal with that at the grassroots, so to speak, for lack of a better term. Yeah.
I mean, youth radicalisation can happen in many different ways, and sometimes it's self-initiated and self-driven. What this is saying is that where it is undertaken by an adult and really grooming occurs, where an adult is seeking to radicalise a children through advocating violence or sharing violent extremism material, that is a more serious version of those offences.
Okay, and just one last question from me, Chair. Will this provision apply to all conduct relating to all protected attributes, or is it only applying to conduct involving race?
So it does not seek to narrow the underlying offences. So for the advocating violence offences, there's a range of protected attributes. It would apply equally to them. And obviously sharing violent extremism material, there's no protected attribute in that matter.
Okay, great. Thank you. Thank you for that, and thanks to everyone for their evidence today.
All right. Well, on that note, thank you very much for that. I just want to thank the attendants of the departments who are here today. And if you've been asked to provide any additional information, which you obviously have, I know you've taken quite a bit on notice. Can I just ask that you try and get that stuff to us as quickly as possible? You know, if you can by this evening, would be ideal, given our short time frame that we're working towards. We'll also send you a copy of the transcript when it does become available, but I'd appreciate if you can assist and work with the committee secretariat to be getting those answers on notice to us as quickly as possible. Now, we're just going to break for about 15 minutes and then come back with the Australian Federal Police. Thank you. Welcome back, everyone. I now would like to welcome representatives of the Australian Federal Police to give evidence at this public hearing today. Now, for the Hansard record, could I ask that you all state your full name and the capacity in which you appear today?
Chrissy Barrett, Commissioner of the Australian Federal Police.
Catherine Van Gerp, Chief Operating Officer, Australian Federal Police.
Hilda Sirek, Acting Deputy Commissioner, National Security of the Australian Federal Police.
Matthew Gale, Acting Assistant Commissioner, Counter-Terrorism and Special Investigations for the Australian Federal Police.
Thank you. Now, as you'd be aware, although the committee does not require you to give evidence under oath, I should advise you that this hearing is a legal proceeding of Parliament and therefore has the same standing as proceedings of the respective houses. Given false or misleading evidence is a serious matter and may be regarded as a contempt of the Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. Also, due to the short time frame the committee is working within to complete its review, please answer all questions or provide information to the best of your ability in the evidence today. As further written answers to any questions taken on notice will have to be provided within 24 hours of receiving the Hansard transcript. Now, I just want to ask, did you have an opening statement, Commissioner?
No, I don't, Chair.
Excellent. Well, we might kick off and go straight to questions. I understand the Deputy Chair, Mr Thompson, has questions. Over to you.
Thank you, Chair, and thank you all for being with us today. Just in maybe to you, Commissioner, just in general terms for you, how are people radicalised?
How are people radicalised?
Yeah.
That's a very broad question. Are we talking about particular people or just radicalisation in general?
Just in your opinion, when how are people radicalised? Yeah, just in your opinion, in any capacity you can tell me.
I can speak to our observations of what we know from our caseload. That's probably the only context I can speak from. And of course, there are various ways that people are radicalised. So it's very hard for me to talk with any specificity because I won't be able to accurately capture everything. I guess I'll just caveat that. But in terms of our caseload, what we see a variety of pathways of radicalisation. We've spoken on the record a number of times, particularly around what we're seeing with youth cohort and how we're seeing particularly youth engaging online and being radicalised through online means. Certainly at the moment that is very prevalent in our caseload. Certainly vulnerable youth who potentially engaging online and are, seeking answers or are curious or are asking questions and are then, taken advantage of by others who are looking to radicalise and, use them in support of extremist views. So that's probably, at the moment, the most prevalent radicalisation we're seeing in our caseload.
Yeah, would you say, or would you think that the radicalisation or the target of youth has increased?
We're on the record as saying that our youth caseload has increased. I've spoken publicly a number of times, that particularly what we've seen since COVID, and the way I would explain that is obviously during COVID we saw a lot of young people who were removed from their normal sort of social settings or their protective factors through their school, their friendship groups, their sporting clubs, and who were perhaps, is seeking for some sort of connection online. So I have spoken about that publicly, the prevalence since COVID of young people online and how quickly a young person can be radicalised because of the depths of the online world. And we know that there are people that are existing in the online world for the purposes of radicalising vulnerable young people.
In regards to youth and then them being radicalised online, would you say that, in your opinion, that this bill goes anywhere near combating that?
I can't give an opinion on that. That's not my role in this hearing to give an opinion on the bill. I can talk to, in terms of the AFP's role, is to operationalise legislation, and that's what we're focused on.
Okay. Would you be able to point to a part of where you would operate a part of this bill that targets online?
Well, it's not just this. We've got multiple mechanisms that we use to target online behaviour. And as I said, this bill will form part of already the suite of tools that we have to combat radicalisation.
How, in your professional opinion, people that have been radicalised or being groomed to be radicalised, how do they obtain firearms?
Again, I can't give an opinion. I'm not here to give an opinion. I'm here to talk to the AFP's role and how we operate in terms of our role and remit. It's also very difficult for me to answer that question. It's a very broad question. There are multiple avenues for people to. Are we talking legally or illegally? It's a very broad question. It's very difficult for me to answer.
Okay, those who you've, anyone that you've investigated, arrested, or any capacity like that, who have been radicalised, if they have firearms, what is the largest percentage of how they get them? Are they legal or are they illegal?
Look, I might at this point throw to our Acting Assistant Commissioner, Matt Gale, who leads our counter-terrorism investigations, to talk about what we're seeing in our investigations in terms of firearms. But I would say we haven't had a high prevalence of firearms.
No, and thank you, Deputy Chair, for the opportunity to speak today. In the current threat environment, we're seeing a number of factors which is really influencing the work that we're doing. You correctly point out that youth radicalisation is one of our key issues. With recent legislative amendments, we've actually got the opportunity to interdict at early stages, as the Commissioner has identified, through offences like the sharing of violent extremist material. So that has really provided us with a mechanism to interdict and disrupt some of these threats earlier on in the piece before it becomes a more protracted threat investigation. With those investigations that we've undertaken, there's actually quite a very small cohort of individuals that have had firearms linked to them. But as the Commissioner rightly points out, that is just one aspect of the threat environment that we're actually dealing with. We do have individuals that have access to lawful firearms. We work very closely with our state and territory partners to actually utilise their state laws as well to ensure that we maintain visibility and provide prohibition orders wherever possible. But it's a very open-ended question in relation to, is firearms one of the key issues that we're seeing there? We see a broad range of threats in that radicalised environment.
Yeah, so I thought, my second question was, is the number of firearms that you're seeing with radicalised people, or people that have been radicalised, is the higher percentage legal or illegal weapons, firearms?
Again, I think it's a difficult question because some of the people that we're interdicting may have access to firearms, but they may not actually be licensed firearm owners, and that could be through familial links or through associates. So again, I'd be reluctant to say that it's a definitive answer in relation to that one.
And I think just to pick up on the point that was made around our early intervention, I mean, for us, that is the key, and that is where we're really focused on that early disruption, and certainly our investigations, working with, state and territory partners, but also offshore partners, getting that intelligence and information very early so that we can take action very early before we've got someone that's, quite a way down a path of planning a terror act or an act of violent extremism.
Thank you. And when this, or while this bill was being drafted, what advice did you provide to the government?
I'm I'm not going to go into the advice that we provided to government. I can obviously confirm that we were engaged as part of the drafting of the bill, but I won't go into what advice we've provided. Needless to say, our advice is based on, our part of the legislation or our role in the legislation, which is to operationalise it, to use it to collect evidence, and then obviously our engagement or our work with Commonwealth Director of Public Prosecutions to then get a matter before court. So that's the aspect that we've been focused on.
Commissioner, was your answer, just to clarify so I understand it, where you don't want to go into the advice given is because of this being an open session, is that right?
I won't publicly talk to the advice that we've provided to government.
Okay. Commissioner, you said at a press conference on the 19th of December 2025 that plan changes to lower the threshold for hate speech will make it easier for the AFP to take quicker action or action quicker. Was lowering of the threshold for hate speech something for which you or your predecessor, Reece Kershaw, had specifically advocated to the government prior to the Bondi terrorist attack?
Again, I'm not going to go into detail in terms of what conversations I've had with government, or indeed I can't speak to previous conversations that the previous Commissioner had with government. My public statement, as you've correctly said, is that lowering of the thresholds would assist us to do our job, but also just to make the point that there's been various iterations, or there's been a lot of work even between then and now in terms of constructing this bill.
Right. So, okay. So we won't go in. Okay. So you don't want to. Sorry. Just once again, I think my headphones might have broken up. So with that, with the quote that I read, you don't want to go into if you've asked the government previously before the Bondi terrorist attack. Is that what you just said? Sorry.
No, I have publicly said that where we see challenges with legislation, I will and I do and I have in instances where I have raised that with government in terms of challenges we might be having with legislation, but I won't go into the specifics of those conversations with government.
Okay. Well, maybe with the functions of the PJSOS, maybe we can revisit this, not publicly. But Chair, that's all I have.
Okay, thanks, Deputy Chair. Now I understand Senator McDonald might have some questions.
Thanks very much, Chair. Thanks, Commissioner. Specifically, I wanted to follow on from some questions that Mr Thompson just raised around consultation. I just want to be clear that the legislation as it stands, you've made some public commentary about it, making it easier for the AFP to follow up on bad actors. But would the legislation as it stands currently have allowed you to take action on these people who've subsequently been identified as protagonists?
Sorry, to be clear, are you talking about the two individuals that were involved in Bondi?
Yes, I am. Yeah.
That's a very difficult question for me to answer, given that we are in the middle of an ongoing criminal investigation. We have a matter before the court. We are preparing a brief of evidence. We are also subject to a review, and as we know, there's a Royal Commission. So it's very difficult for me to answer that question when there are a number of active things, particularly an ongoing criminal investigation.
But you know what I'm seeking to understand, though, don't you, is that what Australians are seeking from this rushed legislation they are expecting that it would make it easier for our organisations like the AFP to more easily investigate and take actions against people who you identify as potentially being involved in generating hate and extremism. So putting aside the specifics of those people, but do you feel confident that this legislation is going to allow you to take faster, more outcomes-driven actions, that you'll be able to take action on people you see generating hate and extremism in Australia?
So if I can just be very clear to say I'm not making any comment about what happened on December 14. I'll make a general comment, just to be very clear on that. I have made a number of public statements where I have said that we are aware that individuals and or groups are very aware of where the legislative thresholds sit, and indeed, we suspect or understand that people are seeking legal advice in terms of where the criminal thresholds sit. I've confirmed that I have provided previous advice to government around some of the challenges that exist with the legislation as it stands. So there are aspects of this bill that will support us in and enable us to seek operational outcomes. Is probably the way that I can best describe it. There are aspects of this bill that will make it easier for us to take action in some of those examples that I've previously spoken about.
Okay, I understand. How about in relation to some of the exemptions around religious text and speaking to, the discussion of the religious text? Will that provide the tools that you need to be able to follow up on people who you believe are generating hate and extremism?
It's really difficult for me to answer that question for a number of reasons. First and foremost, every matter that we investigate, or every incident that we attend, or every action that we investigate is case by case. So it's hard for me to make a sweeping comment about whether or what might happen in a particular scenario, or whether the legislation would allow us to proceed to prosecution. That will be a case by case case-by-case experience for us. And I guess the other thing I would say, like everybody, we only got this bill, late last night. So it's really difficult for me to talk in any absolutes. In fact, it would be irresponsible for me to do that, as we're still working through the bill.
Can I assume, though, that as the Commissioner of the nation's leading policing agency, AFP, that you have been intimately involved in the drafting and direction of this legislation?
I can say that we have been heavily involved in being consulted as part of the drafting of the legislation, yes.
So, just want to be clear, so you received the final legislation last night, probably around the same time that I did and other members of this committee did, but were you familiar with this legislation? I'm just trying to understand. I would hate to have thought that you were opening it up going, oh, this is kind of what we spoke about, or how intimately familiar with the legislation as it's been printed were you?
I can say that we, again, have been heavily involved in the consultation for the drafting of the legislation. I can give you assurance that we have been, yes, we've been heavily consulted as part of the drafting process.
Okay, but the legislation, the black letter law, you saw in entirety for the first time last night?
Yes, so the version that's sitting in front of me right now, we received last night. Just to be very clear, our job is, we are not part of drafting of legislation. We are an operational agency that will provide advice or input, again, related to our role in operationalising the legislation. So again, that is how would we apply it in a operational setting in order to collect evidence, to investigate an incident or an offence, and then proceed potentially to prosecution. So we have been involved, but we are not drafters of the legislation. We are an advisory agency.
I appreciate that. That's yes. You don't draft the legislation, but as you say, as the operational, the organisation that requires this as a tool of trade in order to deliver on Australian safety, I would imagine you would have clear views on what works and what doesn't. And so I'm seeking assurance from you that you are satisfied that the tools that you've been provided in this legislation will allow you to provide as safe a framework as you can in your investigations of hate and terrorism actions.
I can certainly give you assurance that we have been involved, as I said, through the drafting process as an advisory agency. Again, I can say that there are aspects of the bill that will enable us to keep the community safe in terms of where the legislation, where the drafting is. But again, a lot of this, of course, will be case-by-case basis, and until we actually put some of these matters before court or get to a point where we're in discussions with the CDPP about prospects of a successful prosecution, I cannot give 100% assurance. I can say is there are aspects that will indeed allow us to keep the community safe.
Yeah, sure, I appreciate that. Can I just turn now to the gun buyback portion of the legislation? I was surprised when all of these elements had been lumped into one piece of legislation. I want to talk to you specifically about the potential for buyback of illegal weapons. Did the AFP provide input into the structure of the framework of the buybacks to buy back and reduce the number of illegal weapons that are in Australia currently?
We have been involved in, but I wouldn't say that we have had it is not our role, I guess, in terms of the framework that government develops around the gun buyback. Again, we're an advisory agency based on our operational remit and our operational experience, but the framework is not something for the AFP to comment on in terms of the justification for why it's been developed the way it has.
Okay. You would work with your state colleagues around guns, and both legal and otherwise. Have you consulted with them on how you would see the AFP interacting with them with the gun buyback framework?
We have had a number of meetings and consultations with state and territories, yes.
Right. Okay, I won't ask you to reflect on what their views are, but do you think this framework is the best one that Australia can be putting forward in order to reduce the number of illegal firearms in Australia whilst I hope, not impinging on the activities of lawful gun operators?
Again, it's not my role to comment on that. I just reinforce that we have been involved in the development or the consultation where our role is, our remit is appropriate in the context of the framework.
So I'm trying to be respectful of the fact that the government determines the frameworks and the direction of legislation, but we do look to organisations like yours, the AFP, to be subject matter experts. So whilst everybody else is sitting behind desks and formulating this kind of legislation, I am looking to assurance from the AFP that this is the best framework that we can hope for, and that this is going to be successful in reducing the number of illegal firearms and not just being a very expensive budgetary item that won't actually improve on the safety of Australians. And given that I think we all acknowledge that this framework would not have changed the outcome of the recent massacre, because those firearms were, of course, legal and under the threshold identified by New South Wales. So, you know, you've made some comments about, you know, it's not your position to say, but I do need to know that the AFP has provided input and consultation into whether or not this is useful legislation or whether or not this is just political grandstanding.
Again, I can assure you that we have been heavily engaged and consulted throughout the discussions, and also just I think to reinforce your comment earlier about state and territory police. Obviously, they have a significant role in relation to firearms in this country, and I wouldn't speak on their behalf. Needless to say, there has been extensive engagement and consultation.
Okay. Thank you, Chair. I'll leave my questions there. Thank you, Commissioner.
All right. Now, Ms Claydon, you have some questions. I'll hand the call to you.
Thank you very much, Chair, and enormous thanks to Commissioner Barrett and her team, not just for appearing here today, but for the exceptional work that you're all undertaking as part of the investigation into the Bondi Beach terrorist attack. Could I just ask perhaps if you might be able to map out a little bit of the AFP's enforcement activities relating to hate symbols? I'm interested particularly in what you think the shortfalls of the current legislation frameworks are.
Thank you. I will just make an opening remark and then I will throw, I think, to Assistant Commissioner Gale, who has been leading our national security investigations teams, and prior to that, Operation Avalite, where a lot of the investigations into hate symbols have sat within our CT construct. So again, we have provided advice to government around aspects of the legislation, and we, given the time that has passed since that legislation was first introduced, we have had an opportunity to see how the legislation works in practicality, and we've provided advice back to government based on those experiences with the legislation. And then I will say what is proposed in the bill does go to assisting us with those challenges as we've experienced over the last couple of years. But I might throw to Assistant Commissioner Gale just to talk briefly to our hate symbols work.
Thank you, Commissioner, and thank you, Ms Claydon, for the question. In September 2025, the AFP established our National Security Investigations capability, which really did capitalise on the work that was initiated in December 2024 through our Special Operation Avalite. Throughout the early stages of 2025, when we received the new legislation that came in, particularly around hate crimes and hate symbols, we've done an incredible amount of work, both as an agency but across our security partners, that includes ASIO and our state and territory colleagues, in building a capability that is actually quite proactive in identifying this type of conduct and really looking at hardening the environment and creating a real significant deterrent effect. This really did come on the back of some of those protests that we saw towards the end of 2024, which really did present some unfortunate situations in Australia where some of those symbols were displayed and really did impact some of the vulnerable communities within Australia. Since the introduction of that legislation, we actually have undertaken some prosecutions in relation to those offences, particularly in relation to the conducting of a Nazi salute and also the public display of prohibited terrorist organisation symbols. We've also had other offences in relation to make a Nazi salute, and then there's performing a Nazi salute as well. So we've had about 4 individuals charged in the last 12 months in relation to some of those offences. We really do see the value of the engagement here, and I think the new legislation which we're seeing, we would welcome that bringing in, because there is the lowering of the fault element for the prohibited terrorist organisational symbols offences, which does introduce recklessness for us, which is something that is welcomed by the agency. We do see this as a great opportunity for law enforcement, again, to really strengthen that environment and really get back to that key message of keeping, the vulnerable people within our community safe and stamping out some of this hateful conduct that we're unfortunately seeing at increased rates.
Thanks. Is it true to say that the AFP struggles to take enforcement actions against the display of those hate symbols under this current legislation? I know you've got 4 prosecutions, but there have been challenges that you've flagged. I'm interested if you think there is that struggle now, and I guess then what the changes will mean in this current, this proposed legislation before us for the AFP's ability to act against those displays of hate symbols.
Yeah, I think we've been on the record, including at Senate estimates, around this piece of legislation, particularly relating to the hate symbols, particularly on the back of those large protests, one in Melbourne in particular and a few in Sydney in particular, where the complexity of the legislation, or the way the legislation is constructed in terms of what we need to prove in order to obtain a successful prosecution, we have said that is challenging. Elements of that have been challenging. Not to say that we haven't got prosecutions underway, as you've noted, but there is a proposed change in this bill that will, as Assistant Commissioner Gale spoke to, around the fault element, that will assist us in putting forward, more matters for prosecution. And
there's also some other there's also some other enhancements that are being proposed in this bill, which we see as positive, and that's an improvement to the direction to remove a publicly displayed symbol. We're seeking, or it's being sought, that extend to the online environment as well. And the proposed bill also introduces a power for police to seize those items as well, which really does give us a tool to have that immediate intervention and have that removal of harm at the first opportunity.
And that is a big positive change. Of course, in the heat of those incidents, the ability to remove the symbol and seize it, in terms of then providing that, or taking away the thing that is, causing the hatred and the harm, will provide us with, an extra element that we haven't been able to use to now.
Thank you. I was interested in your opinion on the new seizure powers, so that's helpful. And thank you, Chair. That's all I had for this afternoon.
Okay, excellent. Now, I think I understand, Senator Duniam, you have some questions.
Thanks, Chair.
Excellent. Thank you.
Team, thank you. And I'll echo Ms Clayton's remarks. Thank you very much for what the AFP do in protecting our country and in very trying circumstances. If I just could go back to the elements Ms Clayton was talking about, the seizure powers, for example, that's obviously been something that's been on the AFP's radar as an improvement to the legislative framework for some time. How long, roughly, have you been looking or calling for or advocating for something of this nature?
I can't give you a date or a time frame. I can say I think Assistant Commissioner Gale just spoke to when the legislation was introduced.
Yeah, I think, thank you, Senator. It's taken some time for the actual application of the laws, for us to sort of understand from a prosecution perspective what works and what doesn't and what enhancements we really do require. And we did have a couple of matters that stemmed from some of the protest activity in 2024, which did inform our views. We regularly engage with partners across the Commonwealth in relation to legislative reform opportunities. And so this really does form part of our routine engagement with the Attorney-General's Department of Home Affairs through our discussions around national security. So I wouldn't be able to provide you exact dates, but it certainly was conversations that we were having throughout 2025.
Yeah, okay. So shortcomings in the powers afforded to the AFP identified perhaps, you mentioned the events of 2024. That's where it sort of came to mind that extra powers were needed. Is that sort of what you're telling me?
I think it takes some time for us to work through, because it's not just we see alleged offending and automatically we know what the limitations or the challenges are. And of course, I've mentioned CDPP a number of times today. They are a very critical partner in relation to us working with them around, do we have prospects of a successful prosecution here? Ultimately, it is CDPP's decision of whether to take a matter to court.
Yes.
As you know, our role is to collect the evidence, build a brief. So some of that has taken, a little bit of time to work through in terms of where are the challenges, where are the limitations, how might we be able to overcome them? The other thing that we're constantly doing, as well as talking to Commonwealth partners, is our state and territory partners as well. So we know that a number of our state and territory partners also have similar legislation. So often it's also, taking a very keen interest in how their legislation is working or not working, and collectively across state and territory and Commonwealth, who has the ability to take action.
Sure. Okay. Thank you for that. You mentioned, Commissioner, that the AFP received the final package of the legislation last night. I know there's been engagement on the way through. You've also said that it takes some time to understand. I think it might have been you, Assistant Commissioner, who said that that takes time to digest these laws. I mean, is there any way at this point in time the AFP can tell this committee, who on behalf of the Parliament is being asked to assess whether these laws are fit for purpose and should be passed, whether the AFP feel that everything you need from these laws is in here? Have you been able to make that assessment yet?
It would be very difficult for me to say everything we need is in the bill. What I would say is, again, we've been heavily consulted along the way as the process has progressed, and that there are multiple elements in the bill that will provide us with additional powers and ability to take action.
And in terms of application of the new laws, what process does the AFP go through? Let's say we pass the laws next Tuesday, unamended, amended, who knows. What process does the AFP go through after the passage of new laws and for it to be something you go out and uphold in the community?
Internally, do you mean? Like how do we...
Well, internally, whatever process it takes for the AFP to take these new laws, new powers, heightened penalties, you then have to instruct your team on how these laws operate. I presume there's a communication plan that would go with that. Training, perhaps, I don't know. What do you go through?
I will throw to Assistant Commissioner Gale to talk, just based on the experience of the previous recent sort of new legislation that's come in. But yes, there is obviously a requirement to communicate and educate the workforce, but that's something that can be done quite quickly in terms of us being able to operationalise the legislation as soon as possible.
Yep. And we certainly do work closely with our Commonwealth partners in relation to understanding the application of the laws that we need to operationalise. You correctly identify that training is something that we do need to provide our staff. So, on the passing of the legislation, that becomes a priority for us to make sure that we actually utilise those powers as soon as they're made available to us. And there's also often consultation that we undertake with the communities that are largely affected by this, so they can actually understand what these new laws mean for them as well, and making sure that there is opportunities for them to communicate and report those crimes. When we introduced the hate crimes, we did actually introduce on our website public information, which mirrored that was also on the Attorney General's Department website, just so we're going out to those affected communities and really making it aware of the existence of these laws and increasing their awareness so those referrals can come through and we can start those investigations.
And that's been a very significant element of what was Operation Avalite, which was the operation we stood up at the end of 2024, and then now the National Security Investigations teams. It's ensuring that we're having constant ongoing engagement with communities, impacted communities, so that they not only understand the legislation and how we work with the legislation, but also how they can feed information and intelligence to us and reports of crime to us so that we can act on it.
Okay. And do you do any of that preparation prior to the passage of legislation, or work only commences after the passage of the laws?
Well, of course, until we see the final copy of the bill, I mean, we can be prepared, but as you would understand, until...
It may not be law, yes.
Until it's law, that's right, yes.
So has anyone from this team read the bill in full yet?
I have, yes.
You have, yes, okay. And so you've been able to digest the various elements of the legislation as proposed? And
as much as you can in a first read.
Yes, okay.
I'll caveat that. And this was, as I said, we got it late last night. So
yes, I think there were a few lights on late in Canberra last night, including my own. But is there a team within the AFP that are trawling through this, looking at it and trying to get an understanding of how it is as it stands today?
There is a team. I might throw to our Chief Operating Officer to talk to that, but the other point I would make on that, of course, a very important cohort within our workforce are the subject matter experts that are actually working in our joint counter-terrorism teams, that are the ones that would be, by and large, enforcing this legislation. They are the same people that are actively working on Operation ARCS, which is the investigation into December 14. Yes. So these people that are doing the jobs are also our SMEs. So we need to give them an opportunity to provide the practical operational, input at that level. But also we do have other teams working through from a legislative reform perspective.
And just on that, sorry, Ms Van Gerp, so those individuals who are part of those joint counter-terror operations, you said they've got to have time to be able to provide input. What sort of time frame do you typically allow officers of the AFP to provide that feedback?
It's not a static period of time, and it's a rolling, ongoing. Mm-hmm. So you would imagine that there's been a lot of back and forth around the drafting of the bill over the last little while. So of course there's ongoing sort of engagement to the operational areas, which is led under the coup portfolio. But again, I just reiterate. So yes, there are of course SMEs that have had input to the advice that we've provided around the practicalities of the legislation. But again, in terms of this being, the most up-to-date copy or version of the bill that only came in late last night. So there will be SMEs that have had input to this over the last little while, but are yet to see the final version. But I might get Ku just to talk to the internal process.
Sure. Thank you. Senator, we do have a legislative reform team that sits within our Strategy and Performance Office that essentially is our coordination team. So they do the majority of the consultation and liaison with AGD, Home Affairs, and then coordinate with our relevant internal SME areas, our college to develop training materials and whatnot when we need to roll out. So they're really the hub and spoke of giving that expert advice around the legislation, but pulling in the advice from our SMEs depending on the legislation.
When was your team first invited to participate in this process with AGD and Home Affairs?
I don't have an exact date with me, but I can confirm that over the past few weeks, including over the Christmas period, there's multiple consultations, multiple liaisons and paperwork that was circulating for consultation and comment on. So, matter of weeks.
If on notice, could you let us know the first date on which the AFP was invited to be a part of the process? That would be excellent. Were you asked to facilitate any of the consultations that occurred in the drafting of this legislation?
No, we're not the lead on the legislation, so we lead our internal feedback, but the departments are the lead with consultation with states and territories and others.
Okay. And has anyone else at the table had a chance to read the legislation yet? You all have?
Yes. I can provide that over the period of time the Commissioner's mentioned where there's been a lot of back and forth, I've been personally involved in that, to provide that subject matter expertise with the team that sits below me.
Sure, okay, all right. Where was I going with that? I've lost my train of thought now. But what I will ask, Commissioner, on the 16th of December, you provided a statement. And in your statement, I have it here, and while I'm reading this, the other questions I was about to ask might come back to me. You referenced that, and I accept that you may not be able to answer detailed questions about the investigation that's on foot entirely, but you said in relation to that matter, these are the alleged actions of those that have aligned themselves to a terrorist organisation, not a religion. What did you base that statement on?
So that was the first opportunity that I had to speak publicly about the investigation. So 2 days after the attack occurred, it was the first opportunity for me to communicate to the public what we had, the early indicators that we had identified in relation to ISIS, and ISIS being the inspiration, alleged inspiration for the two offenders. So it was my first opportunity to provide some context to the community in relation to what we had identified and learned from the early, the first 48 hours of the investigation. Of course, there had been media reporting in relation to what had been found, flags and the like, but that hadn't been corroborated by police until I stood up. But what I was saying is this was ISIS inspired. ISIS is a terrorist organisation. ISIS is not a religion. That's what my comment was about, to be very clear. We at that point in time, early indications suggested that they were inspired by ISIS. ISIS is a terrorist organisation.
So your point is that it was inspired by a listed terrorist organisation, and as opposed to the Islamic faith itself. Is that the distinction you're making?
So I was very clear in saying this is ISIS inspired. ISIS is a terrorist organisation, not a religion. And we know that ISIS corrupts and distorts Islam as a religion.
Yes, evidently, because I had to do some research myself. The flags that were allegedly found in the vehicle, which apparently the writing on the flag says there is no God but Allah and Muhammad is his messenger, which to me does speak to, but as you've said, your contention is that it distorts the religion of Islam. It is not the religion itself. So that you've clarified that for me, which is fine. Just in relation to Schedule 1 of the proposed legislation and the Minister being satisfied that a hate group has engaged in preparation or enacting a hate crime, is the AFP aware or able to say anything for that matter if any individual in the NSN or Hizb ut-Tahrir organisations in Australia has ever been charged with hate crimes, and was the organisation involved in that crime, if an individual has been charged?
That's not a question I can answer at this table. We might need to take that one on notice.
Yep. If you could, that'd be good, just as I say, in terms of those laws. I'm trying to think what else I had here. Chair, does anyone else want the call while
I'm not aware, but I'll just see if anyone else online had any other follow-up questions. If not, you've still got the call, Senator.
You know, I think I'm pretty well done, Chair. So.
Yeah. And look, I understand we might come back on other matters too. Look, I think on that note, we'll say thank you very much to the Australian Federal Police for appearing here at such short notice. And if the committee needs further information, we'll certainly be in touch. As you'd be aware from what I said earlier, if you're able to provide responses to any questions taken on notice, if you could do so by tonight, that would be great, given the short time frame that we're working towards. I'd greatly appreciate that. On that note, we will also send you a copy of the transcript of your evidence and have an opportunity to request any corrections, should there be any errors. We'll just take a very short break and then we'll move to our next block of witnesses, being ASIO, the ACIC and the AIC. Thank you. Okay, welcome back everyone. We now have representatives of the Australian Security Intelligence Organisation, the Australian Criminal Intelligence Commission and the Australian Institute of Criminology to give evidence at this public hearing today. Good afternoon. Now, for the Hansard record, could I ask that you all state your full names, the capacity in which you appear?
Gus Gilmore, I'm the Deputy Director General Vetting Service Delivery in ASIO.
Mike Burgess, Director General Security.
Heather Cook, Chief Executive Officer of the Australian Criminal Intelligence Commission and Director of the Australian Institute of Criminology.
Adam Meyer, Acting Deputy CEO Intelligence, ACIC.
Rick Brown, Deputy Director, Australian Institute of Criminology.
Thank you very much. Now, although the committee doesn't require to give evidence under oath, I should advise that the hearing is a legal proceeding of the Parliament and therefore has the same standing as proceedings of their respective houses. The giving false or misleading evidence is a serious matter, may be regarded as contempt of the Parliament, and the evidence given today will be recorded by Hansard and attracts parliamentary privilege. And as you understand, due to the short time frame the committee that is working within, please try and answer all questions or provide information to the best of your ability in today's hearing. As any questions taken on notice will need to be provided within 24 hours of receiving the Hansard transcript. Now, did any of you have an opening statement today?
I have a brief opening statement, Chair.
Excellent. And any others? No? Okay. Thank you, Mr Burgess. The call is yours.
It has been 30 days since the heartbreaking and senseless act of violence at Bondi. On behalf of ASIO, I acknowledge the deep pain and grief of the families, friends and community of those killed and injured. ASIO officers continue to work around the clock on this investigation. That's what the families of the victims and all Australians deserve. ASIO will fully cooperate with the Royal Commission on Anti-Semitism Social Cohesion and is currently responding to Mr Richardson's inquiries. ASIO expects scrutiny and embraces accountability, so I welcome the Prime Minister's decision. You'll appreciate that apart from the Royal Commission, there are ongoing investigations and a court case. So I will limit my remarks to the topic before this committee, the Combating Anti-Semitism, Hate and Extremism Bill 2026. The bill will allow ASIO to provide additional advice as part of background checking to state and territory firearms licensing bodies through our federal partner Auscheck, and we will have a role advising the government about groups that spread hate and division. I welcome the opportunity to do more to protect Australia and Australians from threats to security. However, the proposed legislative response is not the only response required. Every one of us has a role to play combating anti-Semitism and protecting social cohesion. Our words matter, our decisions matter, our actions matter. Thank you, Chair.
Thanks very much, DG. Now, I'll hand the call over to the Deputy Chair.
Thank you, Chair, and thank you, Mr Burgess, for that opening. I think this might be better suited to you, Mr Burgess, if you please. Have you seen an increase in youth being targeted for, being targeted to be radicalised?
We've certainly seen in the last several years an increase in minors who are in our priority and counter-terrorism caseload, so there is a growing number. At the peak of COVID, it was 50% of our priority counter-terrorism caseload. That's dropped off, but there's still too many minors in our caseload at this point in time.
How are they targeted, generally?
Good question. So generally targeting their radicalisation or their attraction to violence is happening online. But not solely online, but online is a principal driver.
You've read the bill. I know you probably got it late last night like everyone else and spent up all your night reading it and going through it and highlighting areas. You've read the bill?
I have read the bits of the bill that are relevant to my organisation, yes, and I didn't just read, obviously I got the full exposure draft recently, but we've been consulted all the way through for quite a while on the elements that are relevant to my organisation.
With the minors, as you call them, and the online presence or online as they've been targeted for radicalisation, which part of the bill do you think that is best reflected in?
Well, a couple of things. it's not always the case that individuals, minors or youth or any Australian is targeted online for radicalisation. Typically, they get there on their own or they're associated with people who help them get there. It's rare that we see individuals hunted online and targeted, although I'm not saying it doesn't happen.
Yep. Is there a part in the bill that reflects online?
The bill won't talk. What the bill doesn't specifically address with the elements you're talking about. Although there are elements of the bill that ASIO is associated with that I still think are helpful at this point in time, given our security environment.
Yep. And you've been engaged, you said, by the government on the draft on this bill. How long and when did you start your engagement with the government?
So obviously we have been active since the 14th of December, and the first engagement on legislative change happened on the 19th of December for ASIO.
Okay. What advice have you given the government?
Well, I talk about two elements. If I look at the bill, the amendment bill that's before us, specifically on the use of our security intelligence in decisions or making that available for licensing authorities to make decisions about whether someone's suitable to continue to have or get a firearm. So we've talked about the utility and the practicality of that. And on the listing of hate groups, we've had conversations around that in terms of what my specific advice is about the legislation. That's not my bag. My bag is calling out threats to security and how our information can help the government achieve what it needs to achieve.
And in your, in what you've seen now with whether it's youth or just in general radicalisation, would you say that those radicalised people that are trying to obtain or have access to firearms, they are illegal firearms or legal firearms?
It can vary, so it's not one or the other.
Would you have a higher percentage of one than the other?
I will take that question on notice. I can get you that answer quickly. In terms of when we're investigating someone and where we're doing it through the Joint Counter-Terrorism Team specifically, or not, if they have a firearm, if it's illegal, we would be telling the police that someone's got an illegal firearm if we come across them, but we're not out there policing whether someone should have a firearm or not in that context.
Thank you, Chair.
We are chairless at the moment, Deputy Chair.
Well, we'll go to you, Senator Dunningham.
It's all right. Thanks for that, Chair. Deputy Chair. Yes, Senator Dunningham, you have the call. Thank you.
All right, very good. Thank you very much all for your attendance today. So I might just pick up where Mr Thompson left off. The dates on which consultation started with agencies who've had input into the drafting of this legislation, I might start with ASIO. When were you first invited to have input into the legislation?
19th of December is when we were first engaged in talking about drafting, or not specific, we're not the drafters, but actually the elements of how this could be brought about.
Okay, and it's been an iterative process, I presume, from that point on you've...
Absolutely.
Yeah. So ASIO doesn't have drafters, you don't provide that level of service?
That's not our expertise, we're the security service.
You provide expert advice to the drafters at AGD?
We will provide expert advice about the matter of hand, not on how they draft things. We have people who know our Act, but Attorney General's Department and other lawyers know our Act as well, but we might talk about how changes over here might impact our Act and what we might need to be careful of to preserve ASIO's function. So,
yes.
Or just the subject matter expertise in terms of we know the data and the holdings we're sitting on and how that can be useful for something. And of course, we're active in investigating politically motivated violence and promotion of communal violence, and we can give advice on where we see groups in that context.
Yes. Did you provide any case studies or other resources to inform the drafting? Because obviously a drafter in AGD has, I expect, very little background in your area of work. So was that sort of information provided?
So we've been talking about the things, and I've been on the public record talking about specific groups and where we see them sitting just on this side of the law, so lawful. We've had conversations about that, yes, and that obviously helps people understand where a threshold could be set or how things that the government and the Parliament think should be banned or prohibited can actually be handled under legislation.
Yes. And so did that include case studies, cameos, that sort of thing? I know you said on the
not
public...
case studies, but actually our view on what we're seeing in the security environment in Australia.
Beyond, and were they hypothetical sorts of views? Or?
No, they weren't hypothetical views. So again, I've been on the record talking about both Hizb Ut-Tahrir and the National Socialist Network.
Yes, of course. Is there any of that information that you're able to provide to the committee so that we can understand? I mean, we, within 7 days, will be asked to pass this legislation, and our job is to try and figure out if it's fit for purpose. A range of witnesses have indicated, or potential witnesses have indicated, that it's difficult to assess that. So we're doing our best to figure out whether that's the case. Are you able to provide any of the information to this committee that you've provided to the government to help them get this bill in the shape it's in now?
I'm able to give an in-camera briefing on those groups, but obviously in terms of the conversations we've had, it's actually having a conversation about what we know. And of course, what I've said publicly, there are good public references where you can look at my remarks that might be useful to the committee.
I think I've quoted them from time to time, but a helpful pointer, thank you. That is in relation to the... Did any of the other agencies have input into the drafting as well? Yes.
Definitely.
Could you
very similarly.
Yeah.
Well, not dissimilar to ASIO, we, I think, were initially consulted, or discussions began on the 19th of December. And so, yes, all the way through it has been, we've been consulted on the model in the case of the ACIC, that's in a more narrower respect to how we use our criminal intelligence assessment function to inform background checking on firearms. But we've been, involved in the discussions.
Sure. And was the Institute of Criminology similarly invited to participate in this 19th of December?
Not directly, that would have been through
the ACIC. Okay. And was it were you invited to a group session, or was it by email? How was the consultation undertaken?
I'd have to check on that, but I know the first meeting of senior officials on the matter was on the 19th of December.
And did you attend that?
It was a level or two below me.
Okay, all right. And
I've been engaged in phone conversations with individuals since that time, and I know there have been Teams meetings and phone calls and face-to-face meetings with personnel from respective agencies.
Did you attend the senior officials meeting on the 19th?
No, that would be a different level of all people.
Yes. Are you able to indicate who within the organisation attended?
There'll be people inside my organisation dealing with other people at the working level or more senior levels, but not as senior as the Director General of Security talking about these matters. So the people who are actually doing the hard work to piece this together.
Yes, no, my question was, are we able to identify on notice, if need be, the individual who attended for the respective agencies?
I could tell you now it would be with both Home Affairs and AGD staff.
Yes, I'm asking about the official from ASIO that attended the 19th.
I can't give you their identity beyond myself, because they're protected identities.
Right, okay. I'll ask a question on notice, or indeed if we do have that in-camera briefing, we might be able to...
Sure.
Senator, can I just make a correction?
Yes.
It wasn't the 19th of December that the first meeting of the senior officials group was, it's the 22nd.
22nd was the senior officials, but
we were engaged
on the 19th.
Yeah,
sure, okay. All right. Ms Cook, I just wanted to ask about the status of the implementing of the National Criminal Intelligence System with the states, which I gather is part of the intelligence checking system, or a backbone for it as it's been put to me. Where are we at with that?
So the National Criminal Intelligence System is, as you said, it's a system that has been built to hold criminal intelligence by all jurisdictions, make that information available in real time for frontline policing and other matters. We're in the process, and we call it tranche 2, of connecting mid to late adopters, so the jurisdictions that have not yet connected to the system, for the purposes of provisioning data. That work is underway over the next 12 months. And by the end of that, all jurisdictions will be connected and provisioning data. I should point out that all jurisdictions already are able to access and consume data from the system.
And will that system be necessary to get the National Firearms System up?
The National Firearms Registry, are you talking about? It will be housed within the National Criminal Intelligence System, yes.
Okay, so it's contingent on the National Criminal Intelligence System being operational.
Yeah, it's already operational. I think I need to make it clear. The NCIS is already operational. And there
With
is
tranche 1.
Tranche 2 and most of tranche 2.
Okay.
It's just for, again, certain jurisdictions haven't commenced provisioning data into the system, but it's already operational, being accessed by frontline police every day.
And how far away do you think full operational status is to complete the tranche 2 of NCIS?
Tranche 2 will be completed by the end of this financial year, this calendar year. This financial year, I believe. Actually, let me double check
on notice?
that.
Yes, that's fine.
Yeah.
I don't want to get you in trouble there. I might also just ask Ms Cook about the automation of assessments that's talked about as part of this. I just wanted to get a sense of the extent of the use of automated systems to conduct these assessments. Can you step us through that?
Yeah. So in the context of criminal intelligence assessments, and you'll be aware that the ACIC conducts criminal intelligence assessments in support of MSIC and ASIC access. The process is that the data comes from, or the data in the applications comes from AusCheck in an automated fashion into our system. We are able to automate the initial triaging and checking of that data through our indices. So that is an automated process where an applicant hits against intelligence in our holdings. Then it becomes, it's extracted and reviewed and becomes a more complex case and more hands-on, so not automated. So the automated component is really that initial running against the indices, matching against indices. If there's no hit against indices, an all clear or a non-adverse response can go directly back to AusCheck. So there would be no automation in respect to an assessment that was in any way adverse to the applicant.
Sure.
It's only in the circumstances where they are going to be negatively impacted by the result.
Understood.
So it really allows us to, speed through those, not delay processes for those that are entitled to have their
And with regard to those ones that don't hit an issue against those indices, and so they generate a positive response, is there a spot check or audit system to make sure that we aren't allowing things through a data gap or?
Yeah, so we're always doing quality assurance and checking on the algorithms that we use to make sure that we're not getting a lot of false positives, which can delay a process, but that we've got the system tweaked so that it optimizes the accuracy and the return of the quick return of those non-adverse checks.
Yeah, okay. And so that's human oversight. They'll pull it out and go through it. Okay. And is AI, and obviously it is some version of artificial intelligence that runs these automated systems? I'm no expert in this space.
I might hand to Adam to
Yes, Senator. So we do use data analytics capabilities to manage the checking against those holdings and indices that the CEO has mentioned. In those cases, we would generally find that If anything, we would err on the side of positives, as in we will find something in there that we'll need to resolve, as opposed to having concerns about something not being picked up through those. So we carefully configure the tolerances around those checks to make sure that we have them calibrated. And of course, we regularly are updating our systems in terms of the information and the details within them as well, to maintain that ongoing assurance.
Mm-hmm. Okay, all right, thank you. I think, did Senator McDonald have some questions?
I understand she does. I also understand there's a few other members that wanted to ask questions. So if I might quickly go to Mr. Laxall, I think he has a few questions, and then Dr. Reid only has a couple of questions, and then we can go to Susan McDonald. All right.
I do.
Jerome?
Thank you, Chair.
Yeah,
you got me loud and clear here, Chair?
We do, yep.
Thank you very much. I just have some questions in regards to hate groups and the new framework that's been established, or that seeks to be established within the bill. Just for Mr. Burgess, you've spoken in the past about your concern about groups such as the National Socialist Network and Hizb ut-Tahrir. Could you elaborate about what concerns ASIO has in relation to these groups and how this new hate group listing regime will address groups such as these?
Yes, certainly. I would put both these groups in categories who, as the AFP Police Commissioner has also said, know how to stay on the right side of the law, as the laws currently are. The problem with that is part of their insidious strategy to, in our view, obviously have the potential to rise and increase tension in society. So an example of that would be Hizb ut-Tahrir, and I don't know whether you would have seen the recent letter that they published in the media to the Prime Minister. It's not, no. It's on the internet. It's just an example of a group that will claim that they're talking about the Middle East and only Israel, but when they're talking about Israel and rising up against Israel, and even though they'll say it's a peaceful rise, in this environment where people are conflating the nation of Israel with Jewish Australians, it is driving permission for violence in our society, and they know they're doing that when they do that. It's the same with the National Socialist Network. So as I've said before, this behaviour does actually concern my security service. They don't meet the threshold at this stage for politically motivated violence or advocating acts, and of course that's why they can't be listed under that terrorist regime. But in terms of promotion of communal violence, they're certainly given permission for violence, and they're part of the problem in our society where it increases permission in this tense environment. And we've seen that happen, especially to Jewish Australians, where we've seen threatening, intimidating behaviour go to direct targeting of people, businesses and places of worship, through to now, sadly, the death of many Australians.
How important do you think the establishment of this new framework is to address social cohesion?
From my point of view, the ability for, based on advice from ASIO, where I would put forward to a minister that they consider listing, which is banning one of these hate groups, I think that's incredibly important in the current security environment that we live and operate, and the consequences that we've all seen play out in the last 2 years in particular.
Has the ability not to list groups such as this contributed to, I guess, the environment we're in at the moment? Like, have you been, would you have liked these, if these powers are to go through, would you have liked them earlier, I guess?
So I've been on the record since early 2 years ago, just after the 7th of October, talking about how words matter. Because inflamed language can lead to inflamed tension that can lead to violence. And as I've said, we've certainly seen a transition and a rise of that, more permission for politically motivated violence or communal violence in our society. And we've, unfortunately, as a nation, allowed behaviours to be normalised. And when they're normalised, they're accepted, and that means more of them, it's more permissible and it can happen. So the ability to ban groups that fall within this category, I do think would provide a benefit for our nation.
Obviously, there are safeguards in place for this. Could you just outline ASIO's role in recommending a listing to the Minister, and do you see that there are enough safeguards in this proposed addition to our laws?
Yeah, ultimately, obviously the amount of safeguards is a matter for Parliament, but in terms of I'm satisfied in this case, to initiate a consideration of listing, it has to come from the Director-General Security. Yes, I've been watching other witnesses and evidence before this committee today of if a minister was to say, hey, DG, could you consider this? Of course, we can take questions from anyone in terms of whether they think someone's a problem or not, but it has to be ASIO that forms the view and has the opinion that this threshold on communal violence is met. And under law, ASIO can't be told what its opinion should be, so no minister can direct us to list something that doesn't meet a threshold. We have to go through our rigorous assessment process and actually determine that we think this should be considered for listing. So I think that is a useful safeguard here. And final thing is, obviously, ASIO's Act has 7 heads of security, and the relevant ones here are promotion of communal violence and politically motivated violence. It can't be done for any other reason.
Yeah, my final question is, you just mentioned that promotion of communal violence. When you refer to that, could you just sort of expand or clarify what that means in the eyes of ASIO?
Well, that means where you have individuals or groups who are engaged in activities that are encouraging or give permission to, and the specific definition is in the ASIO Act, but encourages or gives permission to violence between groups in the community.
Okay. Thanks, Mr. Burgess. Thanks, Chair.
Thanks a lot. Now, Dr. Reid.
Yeah, thank you, Chair, and thank you to those in Canberra who are presenting to the committee today. I just wanted to briefly touch on just intelligence sharing in general, and I just sort of wanted to touch base and get a broad sense of how your agencies share intelligence information with state and territory law enforcement, and what do the measures in the bill change in that regard?
The measures in the bill don't change anything in particular other than creating this new function for a criminal intelligence assessment to be requested and provisioned to the Firearms Licence Authority. But day to day, there's extensive intelligence sharing and information sharing with law enforcement partners, intelligence partners, and a range of other stakeholders. So there's already extensive information sharing and intelligence sharing in respect to the ACIC. That's to do with serious and organised crime.
Thank you. That was my question. Thank you, Chair.
All right. Thank you very much. Now, Senator MacDonald, are you there?
Thanks very much, Chair. Mr. Burgess, could I start with you, please? Thank you for being here this afternoon. I wanted to ask you about Schedule 2 of the Act, introducing spreading hatred and extremism as an explicit ground for refusing or cancelling a visa, or not passing the character test under the Migration Act. I just wanted to talk to you about specific examples of what would be considered hatred and extremism.
Well, ASIO's, there's a broader view than ASIO's input into this. Most of that is outside of ASIO's remit, unless, of course, we had someone in a visa situation who we knew or were able to determine through a security assessment process had a violent extremist ideology that would be problematic for the country or see acts of terrorism or acts of politically motivated violence occur.
So would you be able to comment on whether or not family members not passing the character test would be grounds for visa cancellation? I know that you don't do visas, but you do see you do provide the intelligence advice on bad actors in the country.
The character assessment is not ASIO's job. That would happen elsewhere in Home Affairs. Obviously, we get involved if there is promotion of communal violence or politically motivated violence or any other reason in our heads of security that would say someone wasn't suitable to have a visa.
Right. If we think back to the example, actually, don't worry, I'll leave that line of questioning there. Thank you. I want to turn to I'm sorry, just searching for your name, Mrs. Cook, about the background checks for firearm holders. Can you talk to me about what new elements this legislation will bring into place in addition to what the AUSCHEC Act does currently?
Well, this legislation introduces a background check involving a criminal intelligence assessment from my agency, the ACIC, and obviously amendments that involve an extension of ASIO's functions there. But there is no current mechanism for the ACIC to provide an assessment in support of firearms licensing decisions. So this legislation introduces the ability to have that added assurance or that additional element of checking to support firearms license decisions. And for the ACIC, that involves, again, the extent to which denying somebody a firearm would prevent the furtherance of serious and organised crime.
So, is that right? I understood that agencies were able to share information for background checks currently. Is that not the case?
Not in respect to firearms licensing. The ACIC produces criminal intelligence assessments in support of maritime and aviation security identification card applications, but we don't have a function of producing background or criminal intelligence assessments to support firearms licensing.
Right, okay. So what sort of elements will you be checking now that will be made available to agencies?
I think the intention is that applicants for a firearm license, we will be able to look at the data on that application in respect to the individual seeking the firearms license. We will be running that through our intelligence holdings and assessing whether or not there are any relevant connections to serious and organised crime.
And will the activities of immediate family members be included in a person's background checks?
Well, in respect to maritime and aviation security intelligence assessment, the work that we do now to produce criminal intelligence assessments in support of that prescribed administrative action, certainly an individual's associations, contacts, family members already form part of our inquiries and our assessment. So it would be anticipated that that would be the same for firearms licensing decisions.
Do you think that will slow down the time it takes to apply for a firearm licence currently?
I believe the intention is to ensure that it doesn't unnecessarily delay, and that I imagine AUSCHEC will be working through what the appropriate turnaround or service level agreements would need to be with the relevant jurisdictional firearms licensing authorities.
Have you been consulting with the state and territory governments around these changes?
Well, the ACIC hasn't in particular, but the policy development has been led by the Department of Home Affairs, and they've certainly been working this through, but you'd have to talk to them about that.
Well, sure, the policy stuff I understand, but as the operational the agency who will need to carry this forward. Just wondering if you've worked through with any of your colleagues at state and territory levels as to how this will work.
We haven't done that directly, no.
Okay. So you don't know if there are any concerns or otherwise. I want to, how involved will you be with the firearms buyback scheme, or will you be involved with the firearms buyback scheme?
No, the ACIC won't be involved in that.
Okay. What sort of engagement do you have with the legal firearms? Your understanding of that that stockpile?
With illegal firearms, did you say?
Yes.
Yes. Well, certainly, given our mandate, which is focused on serious and organised crime, we look at the full range of illicit commodities that make their way into that milieu, and illicit firearms, illegal firearms are certainly a feature in serious and organised crime. So we spend a great deal of work, effort looking at how they acquire them, how they make their way into the country. Yes, definitely.
Okay, so do you think that the buyback scheme will be an effective way of reducing the number of illegal firearms in Australia?
Well, it's very difficult to say who will decide to, partake in the scheme, but I think there are a range of ways in which firearms make their way into the wrong hands. Do I think those individuals will be looking to give up their firearms? Highly unlikely. But I imagine there may be others that perhaps aren't the proper registered owner of firearms or have acquired a firearm through a different means who would be keen to hand it in. But I simply don't know. Our focus is on, again, the criminal element, and I wouldn't see them featuring heavily in a gun buyback scheme.
Do you have a sense of what's the quantum of illegal firearms in Australia?
I believe we go to 200. It's a very, very difficult thing to assess, but we've been on the record referring to approximately 200,000 illicit firearms.
Right. Okay. So I guess we're trying to manage illegal and bad actors who, and so reducing that number of firearms, I guess, would seem to me to be a better target than buying back guns from legally registered and operated firearms. Did you make any recommendations to the government with regard to the framework of the firearms buyback scheme?
We haven't made any recommendations, but we, again, are aware that firearms make their way into the illicit market in a variety of ways, and it could be through diversion out of the legal market. It can be through theft of legal firearms. So there's a variety of ways in which firearms can move from legal into the illicit market as well. But no, we didn't provide any specific advice on the gun buyback scheme.
Would you have advice that you would be able to provide to us as legislators around how that can be better or can be structured in a way to target illegal firearms? Is there around things like incentives, or what has been effective mechanisms that have happened in other jurisdictions, perhaps overseas?
I'm not familiar with what's happened overseas, but I think any endeavour that involves getting more firearms off the streets is and strengthens import of certain high risk weaponry is going to be part of that solution.
Has the Australian Criminal Intelligence Commission done any work on what has happened overseas? What has been effective buyback schemes or other programs?
No, it's not really our mandate. Like I said, we're focused on tackling serious and organised crime and investigating serious and organised crime. So we're not involved in that sort of research.
Yeah, no, Senator, our focus obviously is trying to understand the nature of the illicit market, the shifts in the illicit market, and to understand both domestically what is happening here, and also, to your point, around offshore, how serious and organised crime are operating both within our near region and beyond, and to understand what implications that may have for the illicit firearms market in Australia. So we're looking at those trends, methodologies, and indeed the networks who are involved to understand and to provide that assessment about what the illicit firearms market looks like now and into the future, and how we can identify opportunities to try to disrupt those criminal networks.
I'm sorry, I just can't see your name tag. Is that Mr. Mayor?
Yes, Senator, it is.
Yeah, terrific. Okay, thank you. I am just interested that how we understand what's happened most effectively offshore. Like, we don't want to reinvent the wheel, do we? So are you telling me that you have no oversight, research, understanding of what's happened in other jurisdictions?
In terms of gun buyback schemes, no, but I'm certain the Department of Home Affairs probably turned its mind to that when they were working on this policy, but the ACIC has not done that, would not have been involved in anything to do with that.
Well, we might ask Home Affairs on notice what research they've done for other jurisdictions to see how that's gone. Dr. Brown, could I turn to you and ask you, in your capacity with the Australian Institute of Criminology, do you think that this legislation, as it stands, will be effective in reducing hate crime and extremism in Australia?
Senator, I can't comment to, I guess, give an opinion on whether it's going to be effective. I can talk to our research around online radicalisation issues. I can talk to work we've published today on availability of digital firearm products, which the legislation may have an impact on dealing with that as a particular issue.
Oh, please do. I'm keen to harvest your expertise.
Fantastic. Any opportunity to talk about our new research, Senator? So the piece published today is based on a survey of almost 10,000 adult Australians. It asks around a range of issues around kind of issues around online radicalisation and conspiracy theories and a whole load of issues. One of the things it asked about, though, was about access to digital firearms products, so particularly like 3D printed firearm plans, if you like. The research showed that just under 1% of adult Australians had traded or bought digital firearms products in the past, or knew someone that had. So it's kind of a broad category. But even with that broad category, what's interesting is that there are a number of factors that point to a higher risk among individuals that are involved with purchasing or trading in digital firearms products, which are different to individuals that don't. And those relate to issues such as more likely to have had criminal justice involvement, more likely to have had criminal justice involvement for violence, more likely to have owned illicit firearms. So I think it points to there being some relationship there between individuals that are engaged in buying and trading in 3D printed firearms and other aspects which would point to making them at higher risk.
So, Dr. Brown, you think that this legislation is going to assist with dealing with those individuals who would normally have access and trade in illegal firearms by addressing digital and printed firearms, do you?
So my understanding is that the aspects of the legislation will clarify and and deal with some issues to do with owning digital firearm plans and sharing those plans through a carriage service. So I think aspects that deal with perhaps dealing with some of the loopholes that may have existed previously is probably a useful aspect to potentially preventing the spread of those products which could end up in the wrong hands.
Were you asked to provide input and recommendations with regard to this legislation?
Our process tends to be more from kind of longer term research aspect, and certainly the piece that we published today was available to Department of Home Affairs prior to the drafting of the legislation.
I appreciate, was it available? Were you asked to speak to it, to draw out some of the detail?
Not directly, Senator, no.
Okay. Do you think that this legislation, as it's drafted, and the research that you've got, particularly with relation to hate crime and anti-Semitism, that it will be effective in combating this?
Senator, I can't speak to that.
No, you actually can. You do the research.
It's not something I can give
this stuff. You are the people who are best placed to tell us what are the, in my opinion, humbly, Dr. Brown, you are the most informed in researching this sort of criminal activity. And so what I'm seeking to understand from you, and in your research, are the elements of this legislation, do you think that they will address those issues?
Senator, I appreciate your views of the AIC. Our work around hate crime in particular is really in its early stages, and it's work that we really started to do in 2025, which the first stage of that culminated with just before Christmas us releasing the hate crimes database. It's really in its infancy as a piece of work. We're looking to explore what else we can do as we move into 2026 to support the government in this area from a criminological research perspective, but it's not developed to a point where really I can comment on any findings from anything that we've produced.
So when did the Institute commence?
In 1973, Senator.
Right, and so you've just started doing work on hate crimes?
In the past we may have touched on aspects. The priorities that we have in our research program kind of ebb and flow and are designed to meet the current needs of the government of the day. Hate crime hasn't been a specific category that we've been focusing on. A wider category of violent extremism has been, and that's focused more on online radicalisation rather than specifically around kind of hate crime, if you like.
Okay. What about anti-Semitism?
Again, I think I'd put that in the same category as the other area.
Okay. So, since October of 2023, hate crimes, anti-Semitism, extremism, none of those things came up onto your agenda as things to be doing research into them?
So we, on the whole, no, we have managed to capture only just a couple of measures in some of the surveys that we've been undertaking, which, if you like, point to change over time in terms of hate speech prevalence. So that's really the only data we've got that I can speak to, if you like, in this space. Two surveys that have covered those issues. We have a cybercrime survey that was conducted in 2023 and 2024, which included two measures, and we have an online radicalisation survey that was conducted in 2022 and 2024, and that has two measures of hate crime, of hate speech as well. What we found across those four measures, 2024 saw an increase in hate speech across those two surveys. So terms of the cybercrime survey, there was an increase in hate speech, the perpetration of hate speech from our figures 1.6% up to 2%. And then from our online radicalisation survey, we found that the hate crime victimisation had increased from 5.6% to 7.7%, and hate crime perpetration increased from 1.4% to 1.7%. So it gives an indication of the changes that have happened essentially since 2023, I guess. But in terms of your question around the implication of the impact of the legislation, that's what I can't speak to. I can speak to some of the background material that we have.
Okay.
For the time, Senator, I'm just mindful.
Thank you. I'll make this my last question, Chair. Which minister do you report to?
Minister of Home Affairs.
And does the minister give you any insight, any discussions? Do you have any talks with the minister about where you focus your research and your surveys?
That's our director's role, Senator.
Yeah, so I meet with the minister regularly. We discuss the AIC, and the minister's office has access and reviews all the publications, has opportunity to ask questions, and the office is quite engaged on the AIC's work, including its most recent work.
I'm just intrigued in the last 2 years that the minister's office hasn't said to you, I'm interested in the rise of hate crime and extremism, and could you do some work on that? It sounds like that's been a very recent body of work.
Well, the work that the AIC has done in respect to the hate crimes database and collecting data and beginning that trend analysis was agreed by government and was directed out of the Home Affairs Minister's office. So that was a direct request, and to accelerate that work. So and that is to get that national sense of prevalence and trends around hate crimes.
And when did that commence?
The AIC published the first dashboard of data just before Christmas. That's considered phase 1. It contains data.
Sorry, when did it commence? When did the work commence?
August.
So discussions commenced in August, and then we got the permission to contact the police commissioners after the Police Ministers' Council on the 2nd of October.
Okay. Thank you, Chair.
No worries. Now, Senator Dunham, I think you've got just a couple of questions.
Just a couple of very quick questions.
Might finish there.
Yes, thank you, Chair. If I could go to an announcement that was made, as I understand it today, and that is relating to the disbandment of the National Socialist Network, who've said as a result of the laws set to pass Parliament, that group is disbanding as at 11:59 p.m. on the 18th. They cite in their statement, and Director General, you're aware of that? Yeah, of course. They cite in that statement that these laws, most draconian in the universe, are making freedom of speech impossible, etc., etc. Clearly, they've seen this identification of formal groupings and hate group listing, etc., as something to try and avoid, which is good in one sense. But is there a concern at all, or has there been any analysis done around now or almost former members of groups disbanding their formal arrangements and going underground? And if so, what can be done to combat that?
So like you, I've seen the media and I've seen their statement, or seen the reporting of an alleged statement. It's our job when, yes, there is a risk they go underground, but our job is to find the people who are hiding themselves in society, and we're good at that.
Yes, indeed. But no analysis has been done of the risk of that happening?
No, we actually did think about what happens if this group is banned, but of course the individuals don't cease to exist. They're still there in society, and obviously the problematic ones we will continue to watch if they continue to be problematic.
Okay, thank you very much. And earlier on in evidence, or in response to a question I asked, you mentioned you might be able to provide further information in camera. Just seeking clarification, would it be more useful as a classified hearing or briefing, or are you happy with in camera?
If you're talking about you'd like to get into a discussion and a deep dive on Hizbut Tahrir and NSN, although that might be moot now if they have taken that decision not to exist, I'd require that to be a classified briefing.
Right. We might take that offline then and figure out which best way to go. Thank you.
Well, on that note, can I just say, sorry,
Chair,
Ms. Cook?
I just thought, just in the interest of time, I can clarify a question that I took on notice from Senator Duniam. The NSYS Tranche 2 completion date is June 2027.
Okay, and one further question on that. Is further, it's a long day, further funding required to meet that completion goal?
No, we're fully funded for completion of Tranche 2. And I did want to clarify, if I didn't, there is already firearm data in NSYS.
You did make that clear.
Yeah, it's just not, it's not the full National Firearms Register, which will be, again, is on a trajectory to be completed later. Yeah.
Understood. Thank you very much.
All good. All right. Look, thank you again for your attendance. If you've asked to provide any additional information, which I know you have, please, if you can try and do it by tonight, that would be great, just given how short our time frame is. I'll also mention to any of my colleagues that are listening and those that aren't, can we just make sure we get a message out there? But if you do have any questions you'd like to write to witnesses today, get them in tonight. That will also 6 p.m. Secretariat says 6 p.m. So you've got just over 35 minutes to get it into Bob and the team. We'll also send our witnesses a copy of the transcript of your evidence and any opportunities to make any edits if there are any errors. Now, on that note, thank you again to everyone. I want to say thank you again to the Secretariat, to broadcasting, to everyone that's assisted today's hearing, and to all the witnesses for making time to appear before today's hearing. I declare the public hearing closed. Thank you.